right, all those who are watching this program right now, either through Zoom or through YouTube, greetings everyone. And on behalf of Nivaran Mediators of Supreme Court of India and Mediation Steadfast, I wish to welcome you to another online learning event. Now, prior to beginning, however, I wish to pay my respects and convey my deep condolences to all those who have lost their loved ones or colleagues in this ongoing pandemic. So please accept our deepest respect for every one of them, please. Now, especially in these uncertain times, if you're here in this event, it speaks a lot about your commitment to learning. Now, after so much planning and discussion by members across 2 continents, that is Asia and Australia, this learning event was initiated for the benefit of those keen to learn so we wanted people to learn more about advocacy skills, and that is why we came up with this workshop. Now, they say an educational treasure is something that follows its owner everywhere. Now, we hope this event will assist you to grow in knowledge and change. It is said the only person who can be considered educated is the one who has learned how to learn and change is the result of all true learning. And in a true sense, intelligence is the ability to adapt to change. Now, man's mind, once stretched by a new idea, never regains its original dimension. So today I encourage you to show some passion for learning. And if you do, you'll never cease to grow. All our knowledge begins with senses, proceeds then to understanding, and ends with reason. There is nothing higher than reason, and to become intelligent is the privilege of mankind. Learning is not easy, and it has never been. To bring a positive change to one's mindset is still more difficult. Now, there's a famous African proverb which says, smooth seas do not make skillful sailors. So do not be dismayed if your journey has been difficult so far. No problem can withstand the assault of sustained thinking. We gather here in this webinar to learn, where collaboration allows us to know more than we can know by ourselves. So use this opportunity, be curious, ask questions in the chat box. They say even the geniuses ask questions. So beyond this webinar, your learning process continues until the last day on earth. But remember, knowing is not enough, we must apply. Willing is not enough, we must do. This learning event is being conducted with the single purpose of knowing more about advocacy skills. However, the great aim of education, as they say, is not just knowledge, but action. We must learn to apply in our professions the new skills that we might learn today. Many thoughts I have just expressed are not mine alone, but were famous quotes of world leaders, artists, authors, and pioneers of science who have always valued respectful learning and thinking. So be respectful, pay attention to the speakers who have gathered here to grace the occasion as they deliver their speeches in which they share their knowledge and experience. Amongst us, we are honored to have the most respected Mayor of Western Australia, Honorable Mayor Tracy Roberts from Wanneroo, and I have the privilege of accompanying here right now in my studio. We also have the former Chief Justice of India, Honorable Justice Deepak Mishra, whose landmark judgments have shaped the future of the world's biggest and most vibrant democracy, that is India. We have Mr. Santan Krishnan, former president at Commonwealth Lawyers Association, joining us from New Delhi, India. Amongst us today, as the keynote speaker, we have the famous leadership coach, Dr. Deborah Dupree, joining us from California. We also have amongst us a former judge, who is now a barrister, arbitrator, and mediator, joining us from Queensland, Australia, Honorable Colin Forrest. Today, we will also hear many experienced senior advocates currently practicing in the Supreme Court of India. Mr. Aruneshwar Gupta, Mr. Jitendra Sharma, and Ms. Suruchi Agarwal. We are truly fortunate to have such an international representation of speakers. We are indeed privileged to have this opportunity to listen to these renowned personalities who were extremely kind to participate in this event. Remember, we are here today to educate ourselves about advocacy skills. It has been for a long time believed. Education is the most powerful weapon which we can use to change the world. Education is not a preparation for life. Education is life itself. On that positive note, I invite you to join me in welcoming all our guests and speakers as we inaugurate this webinar, The Art of Advocacy. Our first speaker today, we are honored to have Mayor Tracy Robert. Now, Mayor Tracy Robert is a passionate and an active community member committed to supporting safe and connected communities. We are extremely lucky to live in an area managed by her office. Her dynamic management of the bushfires in 2020 won her the respect and admiration of all political pundits across party lines. She has been intensely involved in the strategic leadership of the city of Wanneroo, where she consistently advocates for local employment opportunities, community safety, and infrastructure required to service the city's growing population. Her involvement with businesses and members of multicultural community in her constituency is recognized and deeply appreciated. We are honored to call the Mayor, Tracy Robert, amongst us close family friends. Her sharp intelligence and commitment to her role remains an inspiration to all those who had the privilege of knowing her as a friend and as a mayor. I hand the mic to Mayor Tracy Robert to speak to us.
Jagdeep, thank you so very much for that lovely introduction. And it's indeed an honour and a privilege to be here, and I sincerely thank you for the invitation. I would like to acknowledge the traditional custodians of the land on which Jagdeep and I sit at this point in time, the Whadjuk people of the Noongar Nation. I pay my respect to elders past, present and emerging, and also I totally acknowledge those who have cared for the land and continue to do so. It really is a pleasure. And I have to say that normally when I speak without any speech notes and I speak from the heart. However, I've got some very important statistics and facts that I'm going to be reading from. So not often do you find me reading a speech, but I do have some important documentation here that I am going to be reading from. So I'm not going to be looking at the screen the whole time, which is quite unusual for me. So, and if I'll apologise in advance, Jagdeep, that I might go off on a tangent and then not look down at my notes, and I do apologise in advance for that. But I really am delighted to be invited here representing the wonderful state of Western Australia. And I know that we have the Honourable Colin Forrest, who's here from Queensland, but everybody from right around the world. It really is important in times that we do work together, that we work in partnership and that we engage and that we look after one another. For me, that's the most fundamental part of being a leader in any community, whether it's local, state or federal. And I have known Jagdeep for many years and consider it an absolute honour and a privilege to know him and to know his wonderful family and also to be involved in this international webinar. But for those who are dialing in from other parts of the country or the globe, I would like to add a little bit of context about local government in Australia as a scene setter for the session's presentations and discussions. There are basically three tiers of government in this country. We have federal, state and local. There can be a crossover between those tiers. Historically, and interestingly, Australia has had 4 prime ministers who served on local councils. So it really is a good foundation for understanding the issues that affect our local community at grassroots level. And local governments, in fact, play a very important role as an interface with a local community in each district. There are 537 councils across the country, including metropolitan, regional, rural, and remote. And each local government district faces its own complexities, its own challenges, and its own opportunities. For example, roads under local government stewardship add up to roughly 662,000 kilometres, or 75% of the national road length, which is enough to circle the earth 16.5 times. So a lot of roads. And to give you an idea of how local government can vary and its impact all across the communities that it serves, the largest council in Australia by area is the East Pilbara in Western Australia. The East Pilbara covers an area of 379,000 square kilometres, which is larger than 9 of the top largest countries in Europe. It has over 3,000 kilometers of roads, but a population, interestingly, of just 11,000 people. That equates to almost 35 kilometers per person across the East Pilbara Shire. Now you can see why I'm reading from my notes and not committing that to memory. Australia has an average population density of 3.4 people per square kilometre of total land area, making it one of the most sparsely populated countries in the world. You can tell from my accent that I wasn't born in Australia. I was actually born in England. But I've lived in Australia majority of my life, and it's really unusual to see the diversity. And when people visit Australia, and often for those of us in Western Australia, they'll want to pop to Monkey Mia from Perth, and I say it's like it's a 10 or 11 hour drive, and they look really bewildered, and I say, and there's not a great deal in between. So the vastness of the area is what's so beautiful about Australia, but also what opportunities that we have in the area. By comparison, whilst our island nation is 2.4 times the size of India and roughly the same size as Canada, it has a fraction of the population at just under 26 million people. I mention this because each district's population, diversity and size impacts the nature, frequency and cost of amenities and services that local governments provide to their respective communities. While each council across Australia has different needs, delivery, capacity and demographics, a common link to each one is that members of the local councils are members of their local community, representing and advocating for their needs. Each member of each local government is elected by the community to advocate for them with fairness, honesty, respect, compassion and integrity. I have been involved in local government for 18 years at various levels, and I work really hard, as do all elected members right across Australia, in support of the communities that we all represent. I also hold leadership roles. I am the president of the Western Australia Local Government Association, known as WALGA. I'm also the deputy president of the Australian Local Government Association. I'm the deputy president of the National Growth Area Alliance Australia. And of course, I'm the mayor of the city of Wanneroo, which is one of the largest and fastest growing local governments in Australia. We in our city have a land area of 685 square kilometres and 32 kilometres of coastline. We have 36 suburbs and a residential population of more than 212,000. And interestingly, we have 8 babies a day born to our community. Our medium age is 32. And it's a fascinating mix of old and new. And we embrace the ancient Aboriginal culture and the spirit of our pioneers who forged a future for the city of Wanneroo, and also a diverse mix of traditions and customs from right across the world. Each month I have citizenship ceremonies where we have hundreds of people being sworn in as an Australian citizen coming from all corners of the earth. And it really is great to see that they bring their culture to Australia to support and enhance our fast and large growing country. We are really proud of the 41% of residents in Wanneroo who were born overseas, and really proud that they have chosen to live within the city of Wanneroo. That represents an enormous responsibility for us as community leaders. The people who were born or have moved to a district, we are responsible to make sure that they enjoy where they've chosen to live, they feel safe where they have chosen to live, they feel that strong sense of support and that strong sense of connection. And in that we have our rangers with the community. They plan and support a safe city. Their responsibilities covers a whole range of areas, and they work very closely with our local police. One of the things as being an elected member is it's 24/7. There is never a log off or log on. People know where you are, and if people are hurting, people are upset, or people are excited and happy, it's really important that you're available for them to engage, so that you can listen to them, listen to what their concerns might be, and then hopefully be able to resolve them, some sooner rather than later. But when you look at the responsibilities of local government, it's about progression. It's about advocacy with regards to local employment. So our local communities have great opportunity to have local jobs. So that means they're not traveling for hours and hours per week. It means that they can then become more involved in their community, have that strong sense of connection. If they are family members, then they can spend more time with their children. They can volunteer out into their local communities, whether it's part of one of the local football teams, netball teams, surf life saving, but they have that strong sense of connection and community, which is all about lifestyle, and local government underpins that significantly. We also have a very strong relation with the West Australian government. Our Premier, who worked incredibly hard and made some very challenging decisions to make sure that the communities of Western Australia were safe, is to be applauded, and the team that he has around him, and also our federal government and the decision that's been made. One of the key aspects of being in Australia for us is working at our international level and talking and engaging with every single country right around the world. We talk about the support packages, and we talked about, Jagdeep spoke earlier about COVID-19 and the impact that COVID-19 has, and the economic recovery program that's been implemented to ensure that there are a range of assistance and mechanisms to support our community and our businesses. And for example, in Wanneroo, we have specific strategies to provide support to our vulnerable. We've got community response and recovery teams. We're also very mindful of the support for those who are homeless, and working with the state government and many other partnerships and many other organisations to make sure that those who are homeless are rehoused as soon as possible and supported. We know that we're looking more broadly. I'm just looking at my notes here. The city is about to review its regional homelessness plan in collaboration with others, and there is pressure on housing supply. So our Minister for Local Government, the Honourable John Carey, also has responsibility for housing. He's a newly elected minister in the McGowan government, and he's working very hard, working with local government and also with the housing. So he's endeavouring to get out to visit all local governments, but also his responsibility with housing, making sure that the vulnerable and disadvantaged are treated with respect and dignity and are supported. So I guess in conclusion, from the City of Wanneroo's perspective, we're developing our own social licence and to operate a framework from which we work with our partnerships, our sponsorships and our donations. And it's representing the city's holistic approach to business and community support. So working with our local businesses and providing that degree. The Wanneroo Business Association and the City of Wanneroo have got a very strong relationship, and it's a very important relationship. We meet regularly, we ensure there's no ambush, we make sure that there are good strategies and that we can work through any issues. But certainly through the COVID and the impact on their businesses, we're trying to minimise the negative impact on them and support them as best we possibly can, which means cutting through red tape and providing that support so they feel encouraged and they feel buoyed. Just looking at, in January 2018, the Swiss-based not-for-profit World Economic Forum released its annual global risk report, and the report listed the top 5 risks for that year as 1, extreme weather events, 2, natural disasters, 3, cyber attacks, 4, data fraud and theft, and 5, failure of climate change mitigation and adaptation. So who would have thought that at the end of 2018 and in 12 months after that the world would change due to a global pandemic? that no forecaster would ever predict. I think in times of uncertainty and change, an approach like the principles of advocacy, honesty, fairness, respect, compassion, integrity, and self-discipline could never ring more true. And it really is indeed a pleasure to be around the table with so many distinguished and focused individuals, all there and all here to make a difference, a positive difference to our global economy. Thank you.
Thank you, Mayor, for a very informative speech. And I did see that you were not referring to your notes all the time.
I know.
I've known the Mayor as an excellent orator, and it's always a pleasure to hear from you. And you've always been an inspiration for us. So thank you, Mayor, for coming and gracing this occasion. So what we do now is we move to our next speaker. Our next speaker for the day is also from the host country, Australia, and we're absolutely honored to have Mr. Colin Forrest. He is a retired trial judge, an experienced arbitrator, mediator, and barrister who has now returned to the practice at the bar after having served as a trial judge of the Family Court of Australia for past 10 years. Based in the city of Brisbane, in the state of Queensland, Colin now provides his highly sought after services as an arbitrator and mediator in all family law disputes in Brisbane and across Australia. His mediator services are also available in other areas of law, which include, but not limited to, succession law, administrative law, and anti-discrimination law. I invite Mr. Forrest to take the mic and address the audience. Thank you.
Thank you very much, Jagdeep. I'm honoured to be participating in this online training workshop that you have organised. I'd like to begin my session with a formal acknowledgement of the traditional owners of the country on which I live at the moment. They are the Turrbal people and the Yagara people and the nearby Quandamooka people, three different Aboriginal nations with a very proud and long historic connection to this land and an amazingly rich culture that is the oldest living continuous culture on this planet. I have some links myself with England in the same way that Mayor Tracy Roberts does. However, I didn't come across on a boat or a plane from England like she did, but my ancestors about 6 generations ago came out on boats, having been put on those boats by the English Crown for committing small felony crimes, both on my mother's side and my father's side. 6 generations back, they were convicts deported to this land, so they didn't come here of their own choice, though after a very short space of time, the Crown let them free and they became contributors to the society fairly quickly, becoming farmers in the area around the town where I was born in the state of New South Wales. My family moved from the felony crime side of the law to the other side of the law 3 generations ago. My grandfather became a police officer. My father was a police officer, and my brothers and my sister and I are the first of the first generation after those 6 who attended university. I'm proud to say my brothers are both professional men. My sister is a professional woman, and I became a lawyer and have served the law all of my working life. I was a solicitor for 2 years before going to the bar. I served as a barrister for 20 years, principally specialising in family law and succession law. And I took silk in the year of 2010, the year before I was appointed as a judge of the Family Court of Australia, practising out of Brisbane. Having served 10 years on that court as a trial judge, I yearned for the freedom of the bar again, and in February this year I resigned my commission as a judge and returned to the bar and have begun to rebuild a practice specialising in alternative dispute resolution, mediation and arbitration, with a view to trying to help families in dispute stay out of the court process and litigation if they possibly can. So I practiced as a mediator whilst I was at the bar before I went to the court, and have conducted many, many mediations both before I went to the court and now since I've returned to the bar. I've been conducting mediations both in Brisbane and in Sydney. I'm honoured to also be speaking at this event with so many other highly esteemed lawyers in particular, especially it seems from the subcontinent. You are all clearly very experienced and eminent in your field. I pay particular respects to Justice Deepak Misra, who I heard was the Chief Justice of India. I'm honoured and humbled to be serving on the same panel as you, and I'm sure if you all discharge your duties as judges and lawyers, as well as your cricket teams discharge their duties on the field, particularly when they're playing against Australia, that this will be a great workshop. And welcome to the online world. Welcome to Australia. Welcome to wherever you are in the world. I understand there's people watching this all over the world. Now, one of the things I have begun to learn since I returned to practice is how to find my way around the internet and social media. And I joined the online social business network of LinkedIn. And there I made contact with Jagdeep, who invited me to participate in tonight's session. This is an amazing display of how the internet connects all of us all around the world. It makes for a smaller world. It makes for us to be able to make friends with people from different nations and different cultures and work readily and easily with people all over the world. Thank you, Jagdeep, for inviting me. When I asked him what he wanted me to talk about, he particularly pointed me to a book by Justice Abbott Parry, which is called The Seven Lamps of Advocacy. And he said that was the subject of tonight's workshop. And the qualities of good advocacy that are dealt with in that book under the headings of the seven lamps are these: honesty, courage, industry, wit, eloquence, judgment, and fellowship. And certainly they all resonate with me. When I was just starting out as a young lawyer in some 35 years ago, I began my career in the law working as a legal associate to Justice Michael Kirby, who some of you may have heard of. Justice Michael Kirby was the president of the New South Wales Court of Appeal, and he went on to become a very eminent High Court judge in Australia and has done a lot of work internationally. Justice Kirby was my first and great legal mentor, and I worked for him in Sydney for a year. He told me then, when he was encouraging me to work hard and go to the bar, that in his view, the most important attributes of a good advocate were indeed honesty, courage, industry, and wit. Maybe he had read this book by Justice Abbott Parry, I'm not sure, but he didn't tell me about the others of fellowship and judgment, but nevertheless, they are equally good attributes. So tonight, Jagdeep has asked me to speak about the attribute of judgment. And I have this afternoon given some thought to the subject and just written down a few notes of points that I'd like to share with those younger people, perhaps less experienced people. Much of what I say now should ring a bell with the judges and experienced advocates who we have as part of this workshop tonight, but I'm delivering these comments now respectfully to those who are more towards the beginning of their career and hoping to learn how to become better advocates. So I'm to talk about the importance of good judgment in advocacy. The exercise of good judgment is one of the most important attributes of a good advocate. The opportunity to exercise good judgment presents itself on multiple occasions from the moment the advocate receives the brief until she packs up her bags and leaves the courtroom, when the judge has reserved the decision and retired to chambers to write down his or her reasons for judgment. Good judgment really sits closely alongside honesty, integrity, and courage as the attributes of an advocate who is most respected by judges and his or her peers alike. There are so many areas within which an advocate must exercise good judgment. The advocate must exercise good judgment in respect of the theory that he or she chooses for the running of the case, the witnesses that are to be called in the presentation of their case, the witnesses that are to actually be cross-examined in the opponent's case, the points that are to be dropped, and the points that are to be pressed in conclusion in submissions at the end of the case. The good advocate listens to his or her instructors very carefully, but never lets them dictate to her or him how he or she is to run the case, how she is to question witnesses, or how he is to address the judge. The good advocate uses trust and persuasion with her instructors and clients to convince them that her judgment is, after all, the right judgment. That is what advocacy is. That is what it is. It's the art of persuasion. An advocate should always respond honestly, meaningfully, and appropriately to a question asked by the judge. The actual answer to a judge's question should always be proffered when the judge asks a question. It should not be avoided, either because either the answer is not good for the cause of the advocate or because the advocate does not know the answer. There's nothing worse than when answering a judge's question than to simply try and avoid it without answering it. It's better to say to a judge, "I'm sorry, Your Honour, but I do not know the answer to that question, but I will endeavour to find out and provide the answer as soon as I can," than to avoid answering the question. Judges do not like it when an advocate does not directly answer the question that he or she is asked. Good judgment is always far better exercised when the advocate knows the brief inside out. Read it all, understand it all, research around the subject matter of your brief as much as you can. Devote as much time as you have before a case to learning everything there is to learn about the matter and preparing for your examination, your cross-examination, and your submissions. When you know your brief inside out, you feel so much more confident about the case you are presenting. You are also far more likely to be able to get a very good outcome for your client in settlement negotiations. Exactly the same can be said if you are an advocate who is representing a client in a mediation with a mediator rather than a hearing before a judge. The exercise of good judgment also helps you from being prolix or long-winded, both in oral argument and in written submissions. You must carefully winnow the wheat from the chaff in your argument and leave the chaff out. The shorter your oral and written submissions are, relying on your very best points only, the more persuasive your case will be. You would all remember the old story about the person who sits down to write a letter and who says, "I wanted to write you a short letter, but I didn't have time, so I write you this long one instead." It takes a good judgment to craft concise argument, but it is a worthy goal. Make sure that you remain humble and honest when you deal with your opponents. You do not have to put your courage in your back pocket, but you should not be rude and arrogant to your opponent. Good judgment in this regard will help you win and maintain the respect of your opponents. You will only ever be a good advocate if you maintain a good reputation amongst the judges you appear before and amongst your professional peers. they will be the ones continuing to work with you, not your clients. They will just come and go. Your peers and the judges will ultimately determine the levels of success that you have as an advocate. Good judgment is sometimes exercised over a long period of time. The judge, for example, often wisely sits on a reserved decision for some time before distilling the decision and reasons and delivering them in his or her judgment. But for the advocate, during a trial, good judgment has to be exercised very quickly, sometimes on the immediate spur of the moment, without any notice. The decisions that have to be made during a cross-examination are examples of this. A wrong exercise of judgment can, during a cross-examination, have very serious consequences. Indeed, cross-examination is such a special art, it is worth practicing and practicing and practicing. I'm just reminded of the video recording that can be found on YouTube of Irving Younger, the late Irving Younger, who's now deceased, a great American trial lawyer and teacher of young lawyers, where he delivers his 10 commandments of cross-examination. If you haven't had a look at it before, it is a classic and very worthwhile looking at. When I was a young barrister, I typed out those 10 commandments of cross-examination and I pinned them on the back of the door of my chambers to serve as a constant reminder to me as I walked out to go to court every day. Good judgment is not something that you either have or you don't have. It's not something you're just born with or you're not born with. In my experience, it develops with age, experience, and practice. There is a reason why judges are appointed, at least in the common law world, generally after many years of having worked as advocates or lawyers. If you want to be an advocate, the best experience you can gain is by being an advocate. If you want to be an advocate, the sooner you start advocating, the better for you. Your good judgment will start developing and maturing with each and every advocacy experience you have. If you have a setback, do not worry, but always make sure you have a mentor or a number of mentors to whom you can turn for advice and support in times of doubt and setback. It is one reason, of course, why barristers gather together in chambers. Never be ashamed or afraid to turn to another more experienced advocate for support and advice. Generally, knowing what you are going through, they will be generous in their assistance. And as you work through your years as an advocate and gain in experience and confidence, you too will return the professional favour to a younger advocate later on when you become their mentor and advise them on the process. It is the way of the legal profession, particularly the bar, and they are fine traditions that are worth upholding. I'm happy. Those are my immediate thoughts on the importance of good judgment and just some ideas that might help young people who are moving into the field of advocacy. I urge anyone who is watching this or listening to this on YouTube who is thinking of becoming an advocate that it is a worthwhile step. Often the hardest step in becoming an advocate is actually taking the step to do it. For many young solicitors who are thinking about whether or not to make the step to the bar, it's a big step. It can often be a very life-changing step. But I urge you, if you're thinking about it, give it a try. There's no substitute for actually having a go and becoming a young advocate and trying to go to court as often as you can to improve your advocacy skills. If there's any questions that any of you have for me, where I might be able to bring my 20 years as a barrister or 10 years as a judge to the fore to assist, I'm more than happy to help. And you can see my email address. It's colinforrest1960@gmail.com. If any of you ever have any questions or want to communicate with me, please do not hesitate to do so. Thank you very much for your time and giving me this opportunity to meet you all.
Thank you, Mr. Forrest. Thank you so much for your words and words of wisdom. I have made some notes about some of the tips that you have given on advocacy today. They were quite interesting. Thank you so much. To move on with our program, I'm going to request Mr. Aruneshwar Gupta to introduce our chief guest, Justice Deepak Mishra, who we are honored to have on this program. Mr. Gupta, the mic is yours.
Thank you, Jagdeep. Good evening, good morning, and good late evening to people across the globe. It is very difficult task to encompass Honorable Justice Deepak Mishra in a few words. However, let me make an effort. Honorable Justice Deepak Mishra was enrolled at the bar in 1977 and practiced in Odisha High Court. He was elevated as an additional judge of Odisha High Court in 1996 and a judge of the Supreme Court in 2011. After serving as Chief Justice of High Court of Patna and High Court of Delhi, he retired as the 45th Chief Justice of India in October 2018. As a judge of Supreme Court of India, he has been member of about 932 judgments, which is a lot. As a judge, Justice Mishra has delivered several landmark judgments in the field of human rights, civil liberties, rights concerning the lives of citizens, and constitutional jurisprudence. In the historical unanimous constitutional bench judgment on Section 377 IPC, the provisions relating to same-sex relationship was partially struck down. In another judgment, a century-old provision of Section 497 IPC on adultery was struck down, of which he was a member of a bench. It was the bench led by Justice Mishra that allowed the entry of women into Sabrimala temple. Justice Mishra has been a strong holder of constitutional values, citizenry rights, and a staunch defender of the rights of equality, liberty, dignity. I have had the pleasure of appearing before him in large number of matters, and to tell you very, very clearly from my heart, he was the finest judge where I always felt that in his court, justice will be done. And I have seen justice being done in actual effect. Honorable Justice Deepak Mishra.
Yeah. I must start with a note that belongs to Australia. Judge Colin has talked about Michael Kirby. He is a dear friend of mine. He had written an article on a judgment of mine. And I must tell you, I was the visitor of a university and we all decided to confer a decoration of honorary causa on Justice Kirby. He was kind enough to come and accept in a ceremony. That is my connection with Australia. Having said that, let me just float into the introductory address by Mr. Bhatia. He talked about reason and reasoning, how to be asserted by a lawyer. My entry into history shows there are mostly 5 types of reason: imaginative reason, hypothetical reason, emotional reason, sentimental reason, and the logical reason. As far as law is concerned, or the process of argument or the ratiocination is concerned, it is the logical reasoning that matters the most. And in fact, the book that deals with advocacy written by the English judge in 1923, gives emphasis on that kind of reasoning in a different way. True, there are English authors and poets who want a reader to fly with the reason of imagination, or called imaginative reason, but that's for the literature, but not for the law. Second thing that is emphasized is wit. Wit is an art, is also a science. I'll give you one example from the book and another example from my experience. In the book, the author cites an example relating to Lord Mansfield. He did not have much respect for religious holidays, so he used to hold court even on Ash Wednesday. The bar felt unhappy. While a hearing was going on, he told a counsel that I will take this matter on Friday, and Friday was Good Friday. All present in court were astonished, but the arguing counsel very politely and humbly said, as it pleases your lordship. But may I tell your lordship that in history, this is the second time happening. The first that happened was by Pontius Pilate. Lord Mansfield adjourned the case to Saturday. He did not take it up on Friday. Look at the wit and the ingenuity of a lawyer. He concedes to the judge, but puts it on a different platform. Now, let's go back to 1994. A lawyer in mid-30s was arguing a matter before the Chief Justice bench. We have 3-member, 2-member benches, but the Chief Justice was presiding. The challenge was to the constitutional validity of a forest rule. That rule was introduced in the year 1993, amending the earlier rule of 1980. The lawyer argued for 2-3 minutes, then he said that your lordship may be kind enough to look at the 1980 rules. He said no. It was hurting to the counsel. He said no. Well, these rules, 94 rules, will stand on their own or will be shattered because of their vulnerability. Why should we look at the 1980 rules? The lawyer said, my lord, there is a sea of difference, therefore your lordship should look at. Then the Chief Justice said, why sea of difference? Why not ocean of difference? The counsel said, my lord, the English language has its peculiarity. When it rains at cats and dogs, not as tigers and elephants. Similarly, it is sea of difference, but not ocean of difference. It burst in after argued the lawyer is space to. You see, this is the wit in advocacy. Having said that, now we must understand the nobility of this profession. Lord Denning once said, I quote, it is a mistake to suppose that the barrister is the mouthpiece of his client to say what he wants or his tool to do what he directs. He is none of these things. He owes allegiance to a higher cause of truth and justice, unquote. Those are the two values an advocate has to really care for: truth and justice. What Judge Collins had said, that when a court asks a question, it's obligatory on the part of a counsel to answer the same if he knows it, or frankly and candidly state, I do not know the answer, I'll search for it. A candid answer is better than sphinx like silence that's always mistaken, though a polite judge may not react. Sometimes some lawyers say, I will come back to it. That's not an answer. When a judge is asking a particular question at a specific time, you are obligated to answer at that point of time and not come back to it at your own suitable time. Though cultured judges do not say anything. I'll give an example of a cultured judge. When I am saying judge, I do not mean a judge of any constitutional court or a trial judge. Judge is a judge. I mean that way. An American judge was hearing a young counsel who was ill-tempered. The judge did not say anything, had him in entirety. Lincoln was present in court. He told Lincoln, Mr. Lincoln, I request you to admonish this young lawyer as per the highest traditions of the profession. The magistrate sat and Lincoln admonished him almost for 15 sentences which are written. And it's a great passage for every young lawyer to read. I would call it Lincolnian admonition. That is a must for every lawyer. I have enumerated certain qualifications or attributes for a lawyer to practice while he is in profession. First, when he enters into the profession, he must take a vow, I am getting into the place of nobility, simplicity, and intellectual aristocracy. Second, he should harbor the conviction that nothing can lay a foundation stone for success other than hard work. And there is a beautiful chapter in that book, The Lamps of Advocacy Industry. I put it here as hard work. He must believe that he can succeed, and then alone he can pave the path of success. Confidence in oneself is absolutely essential. Sans confidence, you can never grow. And it should not be false confidence. It should be true confidence in oneself. He should concretize that the confidence step by step with humility and respect, destroying all conceptions of fear. Courage is mother of all virtues, and a lawyer must possess that courage with conviction. A young lawyer must not be worried of losing battles, but must prepare himself to fight the war. Winning the war is the embodiment of greatness, because small battles do not really matter to a person who is on the path of glory. My eighth step is he must develop the sense of introspection to analyze and find out his weakness, his limitations. And remember, justification for weakness is no excuse. Do not blame the circumstances. Do not blame the chances. Do not blame the fortune. You make your own fate. Make your own fortune. A lawyer entering into the bar, learning at the bar, must be an inspired being. Must come from research and learning. You do not get inspired by looking at people. You must be attentive. The author in that book really uses good phraseology. Oral knowledge. When you hear great arguing counsel, you acquire oral knowledge about the maxims, principles, and how to present your case. Similarly, your own reading and your own attentiveness makes you a brilliant personality in profession. Another aspect I would like to highlight, presentableness. Your diction, your attire, how do you address, they constitute not a small thing, but a great thing in this profession. And a lawyer must fight for rule of law and the liberty of the people living in society who cannot fight for their own cause. You see, Chief Justice Marshall once told, and I am tempted to quote him, the fundamental aim of legal ethics is to maintain the humor and dignity of law profession, to secure a spirit of friendly cooperation between the bench and the bar in the promotion of highest standards of justice, to establish honorable and fair dealings of the counsel with the client, opponent, and witness, to establish a spirit of brotherhood in the bar itself, and to secure the lawyers discharge their responsibility to the community generally. You see, our Supreme Court had said once, it's very interesting lines, and I quote, law without lawyer loses the locomotion. Lawyer without law misses his function. And that is why a lawyer is an officer of justice, but not only of court. Remember, you are the minister of justice. That is what a lawyer is to be. He has to enlighten himself with 7 lamps of advocacy, and he has to introspect, and he has to think for himself and also be guided by the outer world, which is called observation. In conclusion, I would like to add, I am extremely delighted to be a participant today, and I must be thankful to Madam Mayor Tracy Roberts for sharing our knowledge about the society, civility, geography, and culture of the country, and the others who will be following my speech. And I thank Mr. Jagdeep Bhatia and Mr. Roneshwar Gupta and Mr. Santan Krishnan. Thank you very much.
Thank you, Justice Mishra ji. It is an absolute honor to have you, and you have certainly graced this occasion and been an inspiration for a lot of young people. Many words of wisdom has been spoken, and I believe this is going to be one recording that is going to be worth re-listening, because sometimes you got to listen it a couple of times to understand what your years of experience has been put in just 5 or 7 minutes. So I thank you humbly for coming to our occasion, and I give a great credit to Mr. Gupta for organizing this. So thank you, Mr. Gupta, for getting the chief guest to this occasion, and I give you 100% credit. Our next speaker today is, so we're going to move to our next speaker. So our next speaker today is Mr. Jitendra Sharma. He was the Vice President of Supreme Court Bar Association and has been practicing in Supreme Court of India for last more than 3 decades. He was designated as a senior advocate in 2013, regular speaker at Commonwealth Lawyers Conference in different parts of the world since 2009. Mr. Sharma has conducted workshops for advocacy training skills since 2002. And interestingly, Mr. Sharma's father was also a lawyer, registered in 1930. And his son is also following in his footsteps as an advocate. So that's very interesting. So his family has been part of the legal profession for almost 9 decades. And I have never met someone who can say that. And I'm absolutely honored to have Mr. Sharma on this panel. And it's very honorable to have him here. So Mr. Sharma, the mic now belongs to you. You could address the audience.
Thank you, Jagdeep. I must thank Mediation Steadfast for organizing this event of Art of Advocacy. Though mediation steadfast by the name which itself appears that it is for mediation, and art of advocacy, the advocacy is being normally considered to be an advocacy in a court of law. While in fact, being a mediation in mediation also, art of advocacy is required. The skills of advocacy is required, whether you are representative as an advocate on behalf of client. So it just reminds me of incident which says an engineer, he said, which area should I go? Which field should I specialize? He said, basically develop the skills of analyzing and using the tool. If you are able to use the tools, then the vocation could be anywhere, at any place. So the advocacy skills, if you are able to develop the skills of advocacy, it can be used in mediation, it could be used in the court of law, or any other place where it is required, so before tribunals and other things. I must appreciate organizing Mediation Steadfast, who have organized it, about the 7 lamps. And very categorically, they have planned it. They have given one particular lamp to each of the speakers. That's very worth. I must appreciate that they have given one lamp to each of them. And Collins was given the judgment. And they have given me a lamp of eloquence. Now, out of the 7 lamps which have been mentioned about the honesty, the courage, the industry, weight, eloquence, judgment, and network. Eloquence is the one such lamp which empowers you to communicate the judge or the tribunal, possessing all those qualities, while the other qualities, the other lamps, are just behind. But the shield lamp, the main lamp, is being held by the eloquence, because with the eloquence only you are able to communicate. While in an art of advocacy, oral advocacy is considered to be one of the most important aspects of an advocacy. And it is, if it is to be guarded, and if it is being ejected with the eloquency, then it is wonderful. In fact, eloquency is what has been described under the dictionary is eloquence, fluent or persuasive speaking or writing, according to the Collins dictionary. Now, eloquence is an ability to persuade a judge to consider the case of his client and to decide it judicially. Now, as far as the eloquence is concerned, it is not just only speaking, not assertive speaking. It has to be based on certain principles. And on certain principles, while the young advocates going for everybody must be saying that there must do labor, or you must be eloquent. Eloquent is not just speaking alone. In a court of law, when you are speaking, it has to be balanced by certain principles. While going for young lawyers, with my experience, I would just say there are certain good essential principles to be an eloquent in a court of law. The first and definitive principle is that you must understand the facts. You must know the facts of the case. While knowing the facts, I don't mean that you must know the story of it. While deciding a facts, you must ascertain what the facts come out of it and assert into a good fact and a bad fact. Every case has got certain facts, which are certain goods and which are certain bad facts. Now, what an advocate does it, while coming to a good fact, what he considers to be a good fact is that in order to prove that good fact in a court of law, what evidence he requires to prove that good fact. And what are the bad facts? The bad facts are those facts which the lawyer must, with his ability, is able to either neutralize them or his ability to deal with them. Of course, there are certain facts which you are unable to deal with it, because in each case, there are certain good facts and the bad facts. So the better would be to understanding the facts when I mean it, that you must know the good and the bad facts. Then the second thing which is required for eloquence is you must know the principles of law. Whenever the facts are being narrated to you by a client, a docket comes to you, you have read the facts. After going to the good and bad facts, you come to the second aspect, the legal principles. The legal principles are, you must know what are the statutory law, the provisions, which are statutory provisions which are governed by that. And then you must know the case law, the precedents of the higher courts, what is required. You must note it down so that your understanding with that law would be very important. Long back, it has been considered that law is always a different, keeping in a different way. I collect long back as I just an intern with my father. There is a provision of section 80 CPC. There is another provision in the Australian Civil Code also, where you file a case against a state, you must give a notice. The practice is that you must, the practice prevailing in those days in that district court was that there must be a whole plaint is being written. So every time a new client used to come, my father would say, bring the CPC, and you would read the provisions of CPC. One fine day, when he called me, I said, okay, why you call section 80 CPC Civil Procedure Code? He said, every time there must be, he said, no, it's the same thing, but every time you must do it with a new perspective. So the law is always an ever growing. Then The third thing, when you are going for before a court of law, then you must formulate your propositions. Of course, I'm not going in a trial case where there is an evidence and where there is a material is to be prepared. I'm going straightway to the case stage of an argumentative because of time constraints. I do not want to enter into an area where the witnesses are to be required, how good witnesses to be held with. Collins has referred about it, how to handle a witness, because that's in itself is a big subject. I'm straightway entering into an argumentative stage where the arguments are to be prepared and arguments are to be addressed to a court of law. When you are addressing a court, you must formulate your propositions. While forming a propositions, those propositions are certain based on certain principles. That proposition A, it must be reasonable. Justice Mishra was kind enough to give me a cue that the reasons could be emotional, emotive, while in a court of law, only the logical reasoning is required. So when I say reasonable, that the case theory or a proposition you're making it has to be a reasonable. B, it must conform to law. Because until unless it is conforming to law, nobody will accept. Then an important aspect is that it must appeal to common sense. While a proposition which you are making to addressing to a court, it has to be legal. There can't be a proposition which is against law in a court of law. There could be an address where a person is addressing, there could be a political field or in a social media or wherever it is. There could be a argument or a assertion or a speech which is may not be logical reasoning, but appears to be so much emotions or other things. But in a court of law, it has to be in conformity with law. And then, as it has come in by previous speakers, they have mentioned it, that while you are addressing a court, there has to be the language shall be language which is, because the language is a basic sort of a communication. The language has to be polite. You have to be respectful, and there must be a compassion. Until unless the language is polite, respectful, and compassion, the judge possibly would find it difficult to accept it also. Now, as far as the eloquence is concerned, as I told you, eloquence of manner, in eloquence, there is a physical and psychological side of advocacy. It means that the fluency, effective, forcefulness, and style of their language, strong vocabulary is always a powerful weapon. The vocabulary, it always adds, because the vocabulary gives you more words to express your feelings, more express to give you whatever you want to express therein. And a strong vocabulary gives you assurance to build the self-confidence and increases the personality of an individual. And the words must be employed with eloquence. And the last but not least, I must conclude it. The way the lawyer must be in a position to make a submission in accordance with what the judge expects it. There are two speakers have stated about the other side of the bench that whenever a judge makes a query from a lawyer and the lawyer defers it, evades it, or avoids it, the judge, it is not taken in a right manner, and rightly so. From a lawyer's point of view, if he is not responding to a judge, the judge will be stationary there only. His mind would not move beyond that point, because he must be struggling with that point. And since he is struggling with that point, so whatsoever you are making propositions thereafter, It is absolutely not going. So it is first and foremost principle that whenever of eloquence and an art of advocacy, whenever a judge makes a query, either be in a position to respond. You must. And for that response, what is required, as I told you early in the beginning, you must know the facts of the case. You must have a mastery. This is what, when we say there must be hard work. Hard work is nothing like that you have to do a labor, you have to run on the pillar and post and running and jumping. That's not the hard work. The hard work is you must master the facts. You must know the law. And if you have mastered those aspects, then you will be in a position to respond to the judge's query. And the eloquence, your eloquency would be that to respond the judge in such a manner so that he may be convinced, may not be convinced, that's a different aspect. But you are able to respond. And once you are able to respond, the judge may possibly feel, yes, he is ready and he is prepared. His perceptions may change. In fact, an art of advocacy is you are selling a proposition to a judge who is not ready to accept it, who has got reluctance to accept it. So therefore, rarely would be a case where you will just go and say, judge say, yes, very fine, and matter ends. The eloquency is you are selling a point to a judge who is not very readily to accept it, but you have to make him accept it. And in that, the perception varies. I conclude by saying just one narration which have been heard. A man went to a priest. He said, Father, can I smoke while I'm praying? He said, what is you saying? No, you can't smoke. This is bad. Go away. It was a smart man. He said, Father, can I remember God while I'm smoking? Father said, yes, my child. God is so omnipresent, so generous, so good. You can remember any day, any time, any moment. And look at this man doing bad thing and still remembering of God. The perception changes. So are the words. So the eloquency is not to just endlessly speak. It's only to speak reasonable, within the law, and rightful in the right manner. Thank you so much. Thank you, Jagdeep.
Thank you, Mr. Sharma. Those were really, really very wise words, I must say. And, there's a great emphasis on the language and the eloquence on how we speak. And in today's world, where most people seems to be, texting or Instagram and social media, I think the traditional knowledge of communicating with another human being using eloquent language seems to be, not taking importance. I think people need to go back to the books. I read a long time ago, if you have to speak well, you got to read well. That's an old saying that goes. So, Mr. Sharma, you have definitely touched on that part, and I'm so honored to have you here. And thank you so much for your contribution for today's webinar. Thank you so much. Our next speaker today is yet another experienced senior advocate. So our next speaker is Ms. Suruchi Agarwal. She's a senior advocate, having practiced for about 31 years. Ms. Agarwal has been a senior standing counsel for Income Tax Department in Delhi High Court for about 8 years and practices in the field of arbitration and commercial matters. Ms. Agarwal is an arbitrator on the panel of Delhi International Arbitration Center. This besides her keen interest and work done for investor protection, having represented Securities and Exchange Board of India. She's a mediator with Nivaran Supreme Court mediators, having also trained with ADR ODR. I would personally describe her as a person who I believe is a person who lives with philosophy of simple living and high thinking. And I had the pleasure of associating with Ms. Suruchi Agarwal for some time now. And I would say, beside Mayor Tracy Roberts, she is, Ms. Suruchi Agarwal is my inspiration. When I talk to her, I truly get inspired when I speak to her. So Mr. Ruchi Agrawal, the stage is yours. The mic is yours to address the audience.
Thank you, Mr. Bhatia. And I'm really honored with all these words that you just said. As Justice Deepak Mishra just said, that courage is the mother of all these lamps. And since the workshop has drawn inspiration from the acclaimed work of Justice Abbott Parry, The 7 Lamps, I will be speaking on courage today, as Mr. Bhatia has rightly chosen that word for me. It is very close to my heart. And I must admire his skill in trying to figure out as to who would enjoy speaking on what subject. So I thank him for that once again. This actually, the 7 lamps that Justice Parry from England has emphasized is an endeavor on his part to recapture the age-old principles. These are really the lofty ideals that he wanted to recapture and he wanted the youngsters to follow. And in my opinion, these are not to be merely confused with advocacy skills. Of course, these are advocacy skills, but more than that, I think he wanted to reproduce these really idealistic principles of honesty, courage, industry, wit, eloquence, judgment, and fellowship. And he wanted to reassert that the youngsters follow them. So my address would be more for the youngsters, and I have so much inspiration from the learned judges on the panel, as well as the learned senior advocates. So there is a quote from Justice A.V. Krishna Iyer, whom I chanced upon, and he was a judge of the Madras High Court. He has written a book following the lines of Justice Abbott Parry, and very inspiring words. And I would request all youngsters under the age of 5 years in the practice must go through it once. I'll just forward the name of the book. And I was really wondering where I was when I didn't find that book in my first 5 years. I think it encapsulates the whole experience of a senior in all those years before becoming a judge, when he was giving lectures to apprentices. And every moment of a lawyer's life and every episode that passes has been referred to in that book. It's a very inspiring book, which I would request every youngster to go through. Now, I'm quoting from one of his quotes, where he says that every member of the bar is a trustee of the honor and prestige of the profession as a whole. So it is the duty of each one to carry the banner aloft and never to lower it. So I take the entire writing of Justice Parry in this book on 7 lamps as inspired from this principle. His whole concept, it seems in the book, when I glanced through it and read through it, is that we don't treat this profession as merely a business and trade. He really asserts that these ideals should remain from one generation to the next. It is not as though there is no skill which the youngsters have to learn from the people who have gone. So he has dug into all these books and taken out these principles and encapsulated them in this book. And that's how I see it. Well, to understand courage, one has to go into the origins of it. The origin is in the French word courage, meaning heart and spirit. In other words, courage is an innate quality that resides within the core of every human being. And Justice Parry says that advocacy is a form of combat, where courage is in danger is half the battle. And courage, he says, is as good a weapon in the forum. Forum here meaning the courts and tribunals, is as good a weapon in the forum as in the camp. And the camp implies a war camp. So courage is as important here as in a war camp. That is his feeling. Well, I find a very common thread in all the speakers who have preceded me, and that I feel is knowledge. As said by Justice Deepak Mishra, as said by the Judge Colin Forrest, Mr. Jitendra Mishra has highlighted it. Knowledge is a very important part. So knowledge, according to Justice Parry, is also the power. And you must utilize, given an opportunity, to utilize the knowledge whenever it arrives, and then to use it effectively. That is what proclaims the presence of a lawyer. And so he gives a couple of examples in his book. So the first one, which I'll elucidate, is this is a narration by Sir John Holland with regard to one Benjamin, who was not a very great lawyer at that point of time. I would say a not very great advocate, as called by Justice Parry. He picked up the courage to lament in court that his opponent, no less than Sir Roundell Palmer, has made supercilious arguments. And if he is given an opportunity to argue, he was sure that his suit would be dismissed, that the suit would be dismissed in his favor. So after this lament, when he got the opportunity to argue, he argued extensively based on his knowledge for 3-4 hours. And there were several people who came to listen. And actually the suit got dismissed. So the example is given by Justice Parry to show that this person, from being a normal lawyer, before he addressed the court, from being a normal lawyer, he became a great advocate before he sat down. So that is the role of courage, to utilize the knowledge when granted the opportunity. And then he places emphasis, Justice Parry has placed emphasis on the fact that it is the right and duty of every advocate to appear and to contest all cases, no matter it is a poor, degraded, or even a wicked party, and despite all indignation from the public or the bar. So he says that you must appear for those people. And then in a celebrated speech, he's talking about Erskine's speech at the time of Thomas Paine, when he published the book Right of Man actually, in 1792. And he came in his defense. So there was a lot of passion and etc., where the public there was an indignation from the public. But despite that, he came out in the defense of Thomas Paine. So he wants the courage for defense of all kinds of causes, despite not having a personal interest in it, despite that there would be opposition to it. So according to him, despite the hazards, the dignity, the independence, and the integrity of the bar must be maintained by the lawyers. There are several interesting examples, but one more I will cite from Justice Parry. And that is, he talks about William Henry Seward. It's a very interesting example. This man, Henry Seward, he defended a slave who was emancipated recently. And that person went and killed a farmer, an American, after having been released from slavery. He has killed a farmer for no reason. He has no gain in killing the farmer. He's not wanting to plunder, and there is no provocation. But despite that, and obviously there was an uproar, but despite that indignation and public lament, he defends the person. He defends that Negro. I'm sorry to be using that pejorative sense, but it has been used, the Negro. And the act of courage here is not only the defense of this free man, the person free man, but what has gone down in history is the speech that he gave at that time. And I'll just quote that speech here. So it says he defended the prisoner. An interesting thing is, obviously in an American society, when a farmer is killed and somebody is defending the person who has been released from slavery, that advocacy is not going to be of any avail to the individual for sure. But he says, though his advocacy was of no avail to the individual, his eloquent speech remains a noble statement of the duty of the advocate and a fine example of devotion and courage in the exercise of that duty. So the speech is like this when he says it in court. In due time, gentlemen of the jury, when I shall have paid the debt of nature, my remains will rest here in your midst with those of my kindred and neighbors. It is possible they may be unhonored, neglected, spurned, but perhaps years hence, when the passion and excitement which now agitates this community shall have passed away, some wandering stranger, some Indian, some Negro, may erect over them a humble stone, and thereon the epitaph, he was faithful. And exactly this is what happened. There was a marble on his grave which says these same words. And this person has gone down in the history of the American bar as an advocate who upheld its best traditions and feared not to hold aloft the lamp of courage. So these are the various examples Judge Parry has given, from which I feel that he wanted these lofty ideals to be part of the youngsters' pursuit in this profession. But now bringing it down to the current times, I would say that today an advocate has to fearlessly uphold the interest of his client by all fair means, without fear of any unpleasant consequences to himself or to anyone else. Now, it is the knowledge and skill of the advocate that gives him the necessary courage and confidence to present the case fearlessly and to uphold the interest of the client. The knowledge and the skill can be acquired and developed through mastery of facts, as has been stated by my learned predecessors. Mastery of facts, mastery of law, mastery in drafting, and presentations of convincing arguments. Now, one Queen's Counsel, Tom Leach, when he was addressing the apprentices, he says that the greatest quality of an advocate is courage. And he says you will need it surprisingly more often than you think. It will take courage, and I'm very sorry about this when I say it. This has been said, and with due respect, all the judges on the panel. He says it will take courage to stand up to judges or tribunals who think that you're wasting their time. And arguing a winning case with a sense of proportion. Today, arguing the case with a sense of proportion, even when you're winning it. Arguing a losing case with a sense of dignity. Seeing what works with the tribunal and seeing what doesn't work with the same tribunal. Understanding the time to relieve the pressure by a joke. Most of the times they're bad jokes. Understanding when to completely be serious. Understanding when to persevere. Understanding when to stop and sit down, all require courage. And advocate does a very important thing. He speaks for those who are not able to speak for themselves. And when you win a case for somebody who cannot speak for himself, requires tremendous amount of courage. In fact, to speak for them in losing case or winning case requires all the courage. There is another place where courage would be required. So this is as far as the judiciary and the bench go. As far as the clients are concerned, courage will be required to stand up to clients who try to twist your arm. It must be remembered that you're doing your client a great service by telling them what you think is the correct advice, even if it is unwelcome advice. And you can't tell them only what they want to hear. You will need courage to stand up to tricky or bullying opponents. That's the third thing. To your opponents, the learned counsels who appear against you, you will need courage to stand up to them. And lastly, I would say courage is required to maintain sterling honesty, credentials, strength of character in the wake of new-founded temptations and pressures. So all 3 or 4 aspects require a lot of courage in an advocate. I would be failing in my duty if I don't touch upon courage as regards my own fraternity. Here, I'm not talking of being a lawyer or a counsel. I'm talking of women in this country and internationally. So I'll really be failing. And what I consider courage as far as women are concerned. One has to see what one is doing to be visible. And this is for the women. What are you doing to see that you are visible? What are you doing to see that you're endorsing each other? This factor alone will set up a legacy, to my mind. When you have been endorsed by somebody, invited to a project, which would be of consequence to you, you have set up a legacy and empowered others. You will be doing it similarly and will be setting up that legacy of the others endorsing others. And that will be a collective feminine courage. So according to me, I would actually fail if I don't say this little thing and assert my right of being a woman. And lastly, I'll conclude with a very interesting quote from Roy T. Bennett, who has written the book, the light in the heart. He says, believe in yourself. You are braver than you think, more talented than you know, and capable of more than you imagine. So that is courage for you. Thank you.
That is absolutely amazing. I think that's worthy of the clap, and Mr. Gupta has already clapped for you on our behalf. It's a very strange thing when I and Mr. Rishi Agarwal, we were discussing on, on the topics, and she was saying, oh, I don't know what to say. And then we were thinking of having a contest, who's going to be the best winner of this. And it would be a bit funny if I gave myself as the, as a workshop coach. But here you are, this is the winning speech. I have no doubt, others have spoken so beautifully, Mr. Sharma, Mr. Forrest, everyone, but this is what I call the winning speech, because it came straight from the heart. And as you mentioned about the feminist courage, I have my inspiration sitting right next to me. And last year in Perth, we had this bushfires, and the fires were about 20 meters away from my house. And, my wife was packing up things, getting the dogs, and she was prepared to leave. And I was 350 kilometers away. And the mayor of this town, she was working relentlessly for all the people in this place. And that is where we've got so much respect for a mayor, because as a female, as a woman, it makes no difference, because she's so full of courage. I would request, before we move to the next speaker, I would request the mayor to comment on the courage when she was dealing with the bushfire, because that was absolutely traumatic. I can't even tell you, having the fire 20 meters away from your house, that would have destroyed everything. And she's the one who stood up in the front and dealt with it. Mayor, can you please comment on the courage part of while you were dealing with that traumatic incident?
Thank you. And Surushi, that was indeed a very compelling narrative. And I have written so many things down on my piece of paper. I love the fact when you said advocacy is a form of combat. Absolutely it is, but it's the narrative, and also it's the eloquence about how you do it. I also, previous speaker, I wrote down here that the shorter and obviously good vocabulary, the more persuasive it will be. And I think in my role as a leader within the community, it's having that understanding of the community when people are hurting, how to support them. So my mandate is that I conduct myself with strength and dignity. I go into bat, I go into fight, I go on fearless when I'm fighting on behalf of my community, but I've also got that much softer understanding side when I'm nurturing and comforting and supporting. And sometimes when there's chaos all around, it's important to be calm. And I just loved what you said, and it shone. It just shone from your heart, and that was very, very compelling. And I think one of the things that was reflected in what you said, and if I had to describe you, it would be that you're kind, you care, but you're not weak. Thank you so very much. And to all of the speakers, that it's been absolutely outstanding, the thought processes, but the thought-provoking, I guess trying to sort of put that into a really good snapshot of how I feel right now. It's in awe of the wisdom, the experience, and the knowledge of all of the speakers. So thank you so very, very much.
Thank you.
Thank you, Mayor, for addressing us again. Thank you, Mr. Agarwal. That was really enlightening, I must say that. We're going to move to our next speaker now. Now, our next speaker is someone really, really special to me. And I'll tell you in a minute why the person is so special to me. His name is Mr. R. Santan Krishnan. He's our next speaker, and he's a very special person. Today, I literally messed up the live YouTube by deleting it, and I don't know what I did, but I had to create another one. And he was the first person I called up, and I said, listen, I messed up. I've just deleted it, and this is... So honestly, if somebody had come to me 1 hour before the session and said that, I would have slapped the person, honestly, because I would be so angry. But yet, Mr. Krishnan was so calm, and I was so worried what's going to happen. But you know, his approach to problem solving is so, it's like, okay, it's happened. What can we do now? And you know, and that's why I've got so much respect for him. So he's going to be our next speaker, and he's going to talk on the topic of fellowship. He started his profession as a lawyer during the beginning of 1988 in Hyderabad. He shifted to Delhi in 1988. And since then, a lawyer at the Supreme Court of India. He's also the former president of the Commonwealth Lawyers Association. Now, he is the first person from India or any Asian country to be the president of Commonwealth Lawyers Association, which is in itself a remarkable achievement. And, you know, and to represent India in the Commonwealth Forum, I could not have thought of a better person than Mr. Krishnan. So, Mr. Krishnan, the stage and the mic is yours. We will look forward to hearing from you. Please go ahead.
Please unmute yourself. Mr. Sanjay Ramakrishnan, please unmute yourself.
Am I audible right now? I hope I can be heard. Yes, thank you. Greetings, everybody. When I was thinking of what should I speak, I was jotting down thoughts to be shared with you. But I remember what Colin Forrest said at the beginning. So when I start sharing the thoughts, the bell will be ringing to almost all of you, because there is nothing new I'm going to share with you. Two seasoned lawyers battle out in the front of the court for their respective clients. They oppose each other tooth and nail. In the process, we see a pitched battle. Not only they produce light, but also sound. But what is important here is they do not cross the boundaries. They respect each other while strongly maintaining their position with regard to their client's interest. By the time the matter comes to an end, we are exhausted. They come out of the court, walk towards the cafeteria, and they have together a cup of coffee. The question is, by their conduct, what do they exhibit? Probably, as a member of the bar, they exhibit camaraderie, brotherhood, and above all, fellowship. Here, what strikes us is the book that is written by Justice Abbott Parry about 7 lamps of advocacy, where he speaks of the art of advocacy, and the 7 lamps being honesty, courage, industry, wit, eloquence, judgment, and above all, fellowship. Fellowship is an important aspect of the art of advocacy. And I was trying to figure out, what does the dictionary meaning tell us about fellowship? I was referring to the Oxford Dictionary, which says fellowship is friendliness and companionship based on shared interests. A group of people meeting to pursue a shared interests or aim the position of a fellow of a college or a society. This is what the Oxford Dictionary says. So the question is, it was interesting to see 2 seasoned lawyers exhibiting fellowship while arguing their case before the court of law. But where do you get to learn this? young lawyers, when they join the chambers of a seasoned senior lawyer, they not only get to learn how to prepare for the case by mastering the facts and also the law that is applicable to those facts. In this process, the young lawyer also gets to observe the advocacy skills exhibited by his senior lawyer while presenting the case, and also while facing the judge and the opposite lawyer. And in those adverse circumstances, he gets to observe how his senior keeps his cool on the one hand and at the same time maintains fellowship. A young lawyer who gets to observe all this over a period of time as to how his senior, as an officer of the court, he is not only addressing the court, but also the way in which he deals with the lawyer appearing for the opposite side. On the one hand, he gets to see this. On the other hand, he also sees how a judge is addressing his a fellow judge, where he gets to hear my brother judge. So this is the process through which a young lawyer is trained, which results in not only giving him the understanding of fellowship, but also try to emulate the same when he starts standing before the court. The question is, why fellowship at all? A lawyer is basically an officer of the court. A lawyer assists the court in adjudicating process and towards arriving at a correct conclusion. The two fighting parties understandably would be emotional, and therefore this element of the institution of advocacy is introduced, where the lawyer, through the process of the skills and the art of advocacy, he learns over a period of time. And as rightly said by earlier speaker, that he is not a mouthpiece of his client, deals with the facts of the case and the law applicable to the factual situation, maintains fellowship as a member of the bar, and thereafter pursues his case in effectively assisting the court and trying in the process to get relief for his client. But when you think of the origin of this art of advocacy, and especially when I'm sharing with you the fellowship part of it, we trace the origin to the English courts, where more or less, not only confined to the Commonwealth countries, but beyond, whether it is United States of America or any other part of the world, what happens is, when a young lawyer tries to do his bar examination, in the process gets into pupillage. And pupillage is the period where he gets to learn from the barrister the manner in which the cases are prepared, the mannerisms before the court, and in this process learns fellowship, which he exhibits after he becomes a barrister. When we talk of fellowship, this fellowship is just not confined to the mannerisms which you exhibit in the court of law. Fellowship is also extended to what exactly you do outside the courts of law. When I am saying outside the courts of law, I mean in small gatherings, informal gatherings, formal gatherings, is nothing but extension of fellowship, which we try to do within the court hall. So when I said fellowship within the court hall, outside the court hall, Now let me also tell you what happens beyond the court hall. When we talk of beyond the court hall, I mean to say, for example, the sports. You can take any game for that matter. As cricket is popular, I would take the example of cricket. Lawyers we see exhibit fellowship locally when they get together to play various tournaments. From there onwards, they go to the world stage where we are having a live experience of lawyers from across the Commonwealth countries coming into one platform to play the Lawyers Cricket World Cup. This is nothing but extension of fellowship, which we are expected to see within the court hall, outside the court hall, and beyond the court hall. Thank you very much.
Thank you, Mr. Krishnan, for those great words of wisdom. Truly pleasure to hear you. And I think you're the right person when it comes to fellowship, because you seem to have that art of keeping people together despite their differences. And I think without that art, no progress is possible. And I think the very fact that Nivaran is such a dynamic organization or a group of people, and I think a great credit goes to you, Mr. Krishnan. So thank you very much for being so patient with me and being a great speaker for tonight. Thank you. We move to our next speaker, who I would refer to as speaker par excellence, and we always wait to hear from him. A very wise man. Our next speaker is Mr. Aruneshwar Gupta. He's a senior advocate from Supreme Court and has been practicing law since 1976 in Supreme Court, and has also represented clients in USA and Singapore. He was advocate on record and additional advocate general for the state of Rajasthan in Supreme Court of India for almost 14 years. He was the chief architect of Sports Act enacted by the states of Rajasthan, Himachal Pradesh, and Uttar Pradesh in India, which led to the change in cricket scenes in India by successfully introduction of IPL. So people who are watching IPL need to know Mr. Gupta is the man. He is the person why we have, the way IPL is enjoyed by the world. And we are so privileged to have him on our panel today. Now, apart from being a lawyer, he has also published a translation of a book called Srimad Bhagavad Gita. Bhagavad Gita is the most holy book in the Indian culture. It's an ancient book, and he has done a translation on that, which is commendable. And some of the other writing includes, understanding Supreme Court better, 151 facts you need to know. And he's the co-author of book Supreme Court on Arbitration Law. So, Mr. Gupta, absolute privilege to have you. And the mic and the stage is yours.
Thank you, Jagdeep. Honorable Justice Deepak Mishra, former Chief Justice of India, my friend panelists here, colleagues and associates. Thanks to the Mediation Steadfast Australia and Nivaran Mediators of Supreme Court of India for giving me this opportunity to share my thoughts on the art of advocacy. Incidentally, I am not a bearer of any of the 7 lamps here. I am only a mirror. I am just reflecting the brilliance, wisdom, and genius articulated by the insightful speakers flashing light all around. I've got I love historicity, so I go back. So since the beginning of the civil society, all the kings and every common man needed professional help to objectively express his concerns, interests, and entitlements against violation of laws and his rights, perpetrating illegalities and breaches of contract and trusts. I always say, law is not meant for a sensible person. Law is always meant for the aberrations of the society. Law has nothing to do with men who drive on the left in India and on right in America. Law is meant for the people who try to, jump the red lights or who wants to stop at the green lights. So the law is always for dealing with abrasions. Now, this is the only profession in the world where one is paid to search the truth and speak for justice fearlessly. Back into the history, I go 1,000,000 years back. Now we have got an epic, which is the big epic of Ramayana. So there Shri Ram decides to send Angad, who was the son of Raja Bali, to be his advocate before Ravan and make him understand the futility of war. Now this war would wipe out almost like 50 million warriors, 25 million on either side. There was a stiff resistance by both his younger brother Lakshman, who was like the commander-in-chief of his team, and Raja Sugriv, against sending Angad, particularly because of Shri Ram had killed Raja Bali only a few days back. So they had that, the sense that he may be prejudiced against Ram. So however, Ram narrated to them the skill of Angad, and that settled the issue. Angad had all the attributes of a great advocate, and that was the confidence Shri Ram had in him. So let us hear these attributes, and I think that is the finest attributes I've heard for a lawyer, and that I wish every lawyer could immaculate in himself. First was his presentation as a person, attire, posture, and body language. It was humble, but not meek. It was straight, but not arrogant. It was like a seeker, but not passive. And finally, it was casual, but not devoid of alertness. The speed of his speech or delivery was neither too fast nor too slow, just perfect to enable the listener to be able to hear and understand each word clearly. The pitch of his voice was neither too high nor too low. It was just audible to the hearer with pleasure. Finally, his pronunciation was impeccable. Every word was pronounced correctly with clarity. The voice did not carry any accent or inflection. He knew which word had to be emphasized, when to pause between the words. Pausing is always essential to help audience contemplate on what they had heard and relate it to the issue in hand. Now, when you argue matters in the court, it is very, very important because the judge is getting the feel of what you are arguing. All this comes from self-reliance and self-confidence on the impact that he is making. He had no movements of his body while making his submissions. Like some speakers continue to move up on their toes or move their hands or eyebrows. He would talk straight eye to eye without allowing any digressions. Keep the audience focused to the words and their content. Angad was the most well-read and intelligent person during his times. He was well-versed in all the 4 Veds, the 18 Purans and the 18 Upanishads, and he had a complete understanding of the entire political and social milieu. He was self-actualized, learned it by his deep, insatiable desire to go deep into the fundamentals and understand the basis of everything that came to his hand. But he will never make any effort to brag about his knowledge. He will only speak the relevant, what is relevant to the context. He was representing a patron. Now here patron was Ram, and will always protect his interest. He will do nothing that will impair the interest of his clients at any cost by perpetrating his own prejudices. He will always maintain the dignity of the person he's representing fearlessly. And finally, he knew when to stop speaking. Having made his point and having realized that the person hearing has understood, he will close his dialogue. And I think that is one of the biggest traits, because when we argue the matters, that every judge has got a way of, we can understand when he's thinking and when he's stopped thinking. Some of the judges you can see, moving a pen or something, and then they stop their pen and they keep it on the table. That means it's over. So you must stop arguing. There's nothing left now. So the mind is made up. We wait for the judgment. So now we move forward by about 5,000 years ago and find Shri Krishna advocating a reluctant Arjun standing between about 4.5 million warriors during Mahabharata. And I, take again, Suruchi's word that these are all combats. These are all references in a combat because that is where the advocacy is the highest. You need the advocacy to the best. So Arjun is a very, here there are two characters. Arjun is a very experienced and intelligent warrior, had developed a cold feet, looking to the grave consequences of his actions, in which all 4.5 million people will die. He, like an unwilling and hesitant judge, did not wish to act and decide a case and was finding ways to get an adjournment. He wanted to run away from there. As Arjun put his questions on existing issues and conflicts one after another, Shri Krishna, with immaculate precision and perfection, narrated to him the entire cosmic interplay and resolved the conflicts for all times to come. Now, this is like telling a judge about all the precedents and the entire basic law on the subject. So that's important, and that is only possible if you have a complete grip and knowledge on the fact situation and the legal issues. Not ignoring any one of them, but making him understand the philosophy behind him. Shri Krishna merely helped Arjun to understand the truth, but also not merely helped him to understand the truth, but also brought about realization and enlightenment to enable him to see beyond the mundane and the ephemeral and act to his perfection and enjoy the bliss of his action. Shri Krishna, always smiling, developed the argument on his legs and never told Arjun to do what he should do. He empowered Arjun to think correctly and act exactly the way Shri Krishna wished him to act in the existing facts and circumstances. That perhaps is the greatest art of advocacy. Unlike the dialectics and rhetorics prevalent during the times of Socrates, Plato, and Aristotle. Now, this is something where I would like to add a few words here. And that is that the judge, end of the day, you don't tell the judge that this is what you have to do. You have to help him to come down to the right conclusion. And incidentally, that right conclusion must be the same that you are looking for. Now, that's the art. He should not go to the other side. He should come to that same conclusion that we want him to come to. And that requires a lot of, it needs all the lamps to enlighten together. Now we come down to the present age. Each senior in Supreme Court who have watched, briefed, and interacted in last 45 years of my being there had a unique gift. And I always say this to all my interns and everybody, everybody's got a gift. So let us find our gift. So these are the gifts which I felt that they have got. Apart from all that we have heard from the profound speakers today, let me share it from my personal experiences. Mr. C.K. Daftari, the second Attorney General of India, whom I saw moving slowly with a stick in the corridors of Supreme Court, was famous for his wits. I briefed Mr. Lal Narayan Sinha, the fifth Attorney General of India, in a few cases. He was extremely unassuming, simple, humble, very precise, and absolutely non-repeating. He will never repeat his argument a second time. The judges were always extra attentive when he was making his arguments, lest they may miss a word. And in fact, once I asked him, I said, look at some of the lawyers here. He said, Aruneshwar, they have to do their job and I have to do my job. So I am doing it successfully. So I expect them also to do sensibly. And that's the way it goes on. I had occasion to hear Mr. Nani Palkaiwala in at least 3 matters. He would give easy to understand common examples and a complete total command on facts and figures. In fact, he used to recite his budget speeches, giving facts and figures about the budgets, even without having a paper in its front. That was famous about him. Mr. Ashok Sen, I think one of the most reverend senior whom I briefed a lot, the longest serving law minister of India in cabinets of 3 generations of prime ministers, Nehru, Indira Gandhi, and also Rajiv Gandhi, had a memory of an elephant. He could tell you the page number of your brief years after you have briefed him. And I've tested it personally. So I can say that he said, yes, Mr. Gupta, in that page, at page 20 on the right-hand side, this was written. I remember it. I gave you opinion on that also. He knew every object and reasons of all the statutes. So it was it was a treat to hear him when he get into the validity of these acts and all. He knew almost all judgments of Privy Council, Federal Court, and House of Lords like the back of his hand. His library, this is very, very important. And I think this is very important for each law. His library was better equipped than the Supreme Court Judges' Library. Not the Supreme Court Library, but the Supreme Court Judges' Library. In fact, he had some of the law reports, which even the Supreme Court judges, when they wanted to read it, they got it from the Ashok Sen's library. Mr. F.S. Nariman has a most robust common sense, very quick in reducing complicating issues to the first principles. Mr. Soli Sorabji had an outstanding court craft. I have seen him in many cases and I briefed him. I saw him getting order where he wanted an order, a similar order, but slightly a different one. I gave him the order, but he would not give it to the judges. And he got that order, keeping the order in his hand. But this is something, a brilliant court craft. My first senior, Suresh Agarwal, S.C. Agarwal, who retired as the judge of Supreme Court of India, was called the walking encyclopedia of Supreme Court judgments. He had citations of all the judgments in his head and would open them up as a juggler takes out handkerchiefs from the hat, or sometimes they take out hands, and so he can come out with every judgment he has got. Mr. R.K. Gar, another senior and a partner of Suresh Agarwal, with whom I practiced initially my first 2 years, always told me, now this is very, very important. I think this is something which is very important for everybody. Learn to use the Supreme Court as a tool of social change. Now here is a direction. It is not merely saying something, but he gave a direction. He continued to argue national socialism. Now that was his philosophy as a constitutional goal, and saw that the Supreme Court move in that direction. His perseverance and contribution in development of constitutional jurisprudence is absolutely unparalleled. Now, this is what I'm talking is 1970, I would say, because Gajen Gadkari started arguing labor matters. So it almost started in 58 to almost 90s, till where he gave his whole philosophy. But by the time he said, now the judges themselves are speaking what I wanted them to speak. So till Justice Hegde and all, he had a lot of fight, but after Justice Matthew and Justice Krishna and Justice Desai and Chinnappa and they all came up, he had nothing more to say because they were carrying the lamp on their own shoulders. I have not seen another senior like the others whom I worked for 4 years, Mr. P.R. Mridul, having a better command on English, fluency in order. One of the conditions which I saw him, I was with him for more time I spent in my home. He would regularly read novels and would pronounce every new word 20 times that he came across. So when I was in my chamber, sometimes I would hear him, reciting a word till he get on his tongue. Now, that's how you develop, the way fluency of the word that you talk. His classic and constant reminder was, law is not merely knowledge, but application of it to the facts in your hand. And that is something which I have always tried to do. People know law, people know facts, but how to apply law to the facts is something which is very, very important. Friends, advocacy is an expression and manifestation of spiritual energy of truth and justice, which alone can lead to development of a conflict-free society, living in harmony and bliss. And I take Justice Mishra's word with allegiance to a higher cause, in the words of Justice Deepak Mishra. Thank you.
Thank you, Aruneshwar. Thank you so much. Thank you so much. With your vast experience, you have wonderfully utilized it, and all the 7 lamps of Justice Barrett, they are being introduced in this legends of Supreme Court. Those who know about the practice in Supreme Court, they know all those legends, and each one of you have mentioned about it. You have very aptly used the first advocates being an Angad and Shri Krishna. That's a wonderful assimilation. And those who understand the Mahabharata and Ramayana, they will appreciate it, the role of Krishna and Angad. Now, thank you so much, Arun. Now, our next speaker You have been seeing him for a long time, and on this on the screen, and he's a vociferous book writer. He was born in India, but he is lighting his lamp in Australia, and the light is emanating in Australia is coming, and we are all seeing it. The next speaker is Jagdeep Bhatia, who has introduced the concept that mediation is steadfast. And as a vociferous writer of a book, he has written Amanishad. Amanishad is basically a combination of two words, which shows his influence of Upanishads, the sacred books of Hinduism and the philosophy. And the Aman means peace, which he believes in the world that should prevail. So I request and I invite Jagdeep Bhatia to share his ideas, share his thoughts. Over to Jagdeep. Jagdeep, all yours.
Thank you, Mr. Sharma, for a very kind introduction. My topic for speech today is going to be the art of advocacy, the lamp of wit. Justice Deepak Mishra has already touched on that subject. And so this is a well-prepared speech, and I will be referring to my notes throughout the speech because it is absolutely impossible for me to remember everything because there is so much being shared by people on this topic. And I would feel very honored at the end of my speech, which should not last more than 6 minutes, if Justice Deepak Mishra could comment on it because he has touched on this topic of wit. So I'll proceed with my speech now. So the art of advocacy, the lamp of wit. Upon the altars of justice, the advocate must keep his 7 lamps clean and burning brightly. Yet there are principles of advocacy, and if a new generation were to forget to practice these, it would indeed be a lost art. These are the words of Justice Edward Abbott Perry in his book, The 7 Lamps of Advocacy. From the earliest time of Marcus Cicero, who was an advocate in the Roman court in 50 BC, he was noted for his jest. Wit has been a light to lighten the darkness of advocacy. Justice Perry perhaps called wit as one of the 7 lamps of advocacy, as it lightens the gravity in courtroom, even for just few seconds. Interestingly, while researching, I found 2 more books on the topic titled Wit and Humor of the American Bar, published in 1905, and The Wit and Wisdom of the Bench and Bar, published in 1882. The thoughts in those books seems to echo in 7 Lamps of Advocacy, which was published in 1925. And all this knowledge came across only researching on the topic. And that's the beauty about these webinars. When you participate in these webinars, you have to research to speak, and then you just come across this knowledge which was eluding you, and you did not know that it existed. Now, in the book, The Wit and Wisdom of the Bench and Bar, the author honorary F.C. Moncrief mentions, and I quote, "There have always been some more or less rough and ready methods of handing down the wisdom of past ages to posterity, and imperfect as those methods have been, we are able to console ourselves with the thought that the only wisdom which will stand the test of time has filtered through them." He further adds, "A vast amount of wisdom and wit is yearly lost to posterity by our imperfect means of retaining it." So even at that time, he was a bit concerned that the knowledge of advocacy may get lost if we don't find means to pass it on to the next generation. And that is the whole idea of this webinar, is to have such experienced speakers to come and share their knowledge so we can pass it on to the next generation. Now, in the book, it is interesting to note that the author does not speak about wit and humor, but wit and wisdom. Now, wit and wisdom adorn each other, says honorary F.C. Moncrief. Later in the chapter, he writes, "Wit and wisdom though may linger at length. So right, wit and wisdom, though may linger at length, seem to come to console in consequences of their persistent effort. A man cannot speak forever without saying something good. And hearing those words, a trained mind could rightly say, wisdom is the daughter of experience. Now, in our age, wit and wisdom seem to have been more loosely replaced either with wit and sarcasm or wit or humor. So instead of wit and wisdom, we seem to be more concentrating on the humor side of it now. Now, according to the Oxford English Dictionary, wit can be understood as a keen intelligence or else a natural talent for using words and ideas in quick, amusing ways. Humor, on the other hand, can be defined as the quality of being amusing. Now, there are some overlapping elements and yet certain things that set the two apart, that is wit and humor. A wit involves mental sharpness and clear understanding of the situation. It is an ability to instinctively respond with a relevant comment or comeback. Sometimes wit can make a quick point where 1,000 words cannot deliver. Wit, wisely used, bridges difficulty, smooths away annoyance, turns aside anger, in seconds laughter. Wit can turn the judge from an unwise course. Wit and courtesy are indeed complementary and can refresh the spirit of the wary judge. Justice Perry, in his book, 7 Lamps of Advocacy, has issued a warning though. The medium in all things. Satire and irony is often in danger of being misunderstood. Wisdom is a timeless virtue. Wit certainly arouses amusement in the listener, but it may not always be funny. In the article, 8 Horrible Courtroom Jokes and Their Ensuing Legal Calamities by Jeffrey Sand, in the matter Roe and Wade, defending a case of Texas abortion restriction before the Supreme Court, attorney Mr. J. Floyd decided to open an oral argument against 2 female attorneys with a sexist joke. Floyd begins, "It's an old joke, but when a man argues against 2 beautiful ladies like this, they are going to have the last word." The joke was considered demeaning and not least being funny. So it is vital to remember a good advocate does draw attention to himself, but should be for the right reasons. But when the judge initiates humor, that should be approached with some caution. In the article, judges target courtroom jokes at rookie lawyers, struggling lawyers, and lawyers they disagree with by C.J. McKinney. It is considered a very bad sign if the judge is trying to lighten the mood. New research shows that the jokes from the bench are usually directed at losing side. The researchers who examined 9,000 examples of judicial jests say that the justices direct their most humorous comments at the advocates who they disagree with and those advocates who are losing. In the article, Judicial Humor in the Australian Courtroom by Sharon Anliu, Kathy Mack, and Jordan Tuton, judicial humor is regulated to maintain core judicial values of impartiality and neutrality. Limiting humor can also be important to ensuring appropriate courtroom decorum. These controls on judicial humors are designed to maintain the legitimacy of judicial authority and enhance public confidence in the judiciary. Former Justice Glenson notes that judicial humor can be detrimental to the core value of impartiality, in line with international judicial conduct guides, which make explicit the possibility of judicial humor eroding impartiality. Inappropriate humor may constitute judicial misconduct under the law of the relevant jurisdiction. Australasian Institute of Judicial Administration Guide to Judicial Conduct recognizes the presence of humor, commenting that the trial of an action, whether civil or criminal, is a serious matter, But that does not mean that the occasional humor is out of place in a courtroom, provided that it does not embarrass a party or a witness. Determining whether judicial humor is appropriate or acceptable is a complex task for judicial officers. In an essay, The Role of Humor in Judicial Opinions by Lucas K. Horry, when judge does not have the advantage of naturally humorous fact pattern, some provoke laughs through literary devices that are unorthodox in legal writing. The poem is one of the most common instruments of judicial humor. In the case, Fisher and Lowe exemplifies one of the most successful attempts at incorporating poetry into legal opinions. It was a tort action in which the plaintiff alleged that the defendant's automobile had struck her beautiful oak tree. The trial court granted summary judgment to the defendants, and on appeal, Judge John H. Gillies drew upon Joyce Kilmer's poem Trees to dispose of the matter. He quoted the following verses. "We thought that we would never see a suit to compensate a tree, a suit whose claim in tort is pressed upon a mangled tree's behest, a tree whose battered trunk was pressed against a Chevy's cumbered crest, a tree that faces each new day with the bark and limb in disarray, a tree may forever bear a lasting need for a tender care. Flora lovers, though we three, we must uphold the course decree affirmed." So that's a bit of a humor coming through poetry. Now, Marshall Rudolph, in his article, Judiciary Humor, a Laughing Matter, the general opinion remained judicial humor is basically the right thing in the wrong place. People should enjoy a good laugh, but not in the traumatic and expensive context of litigation. We must recognize that the judiciary is composed of human beings who, like lawyers, stand to benefit from a set of enforceable ethical guidelines. Ramifications of judicial humor abuse are sometimes apparent only upon close examination and reflection. Now, in the Indian context, contrary to popular belief that the Indian courts cannot take a joke, there has been numerous instances that had a fusion of both witticism and hilarity. And we also heard Advocate Aruneshwar Gupta mention in some of those incidents in his speech. Now, in the popular article, Wild Wild Wit, A Lawyer's Weapon by Madhumita C., published in September 2020, the writer mentions several instances, including where in the Supreme Court, Justice Kuldeep Singh is believed to have demanded G. Ramaswamy, who was an attorney general at the time. So Justice Kuldeep Singh said, "You think we are fools?" To which Ramaswamy replied with some gravity, "My lord has put me in a very difficult situation. If I agree, I am in contempt. And if I disagree, I commit perjury." That got even the judges laughing. In another case that involved G. Ramaswamy before Justice Venkatachalya, Ramaswamy said, "My lord, my client is poor and in hardship." The judge quickly contradicted. "Look at the balance sheet on page 63, Mr. Ramaswamy. Your client's turnover just 3 years ago was rupees 50 lakh, which is about 95,000 Australian dollars. To which G. Ramaswamy stated, "I know, my lord, but that was before they engaged me." So I can't help laughing at that one. So to conclude, it is critical to remember knowing how to exercise self-control when the temptation to be humorous arises. In addition, one of Australia's best advocates, Thomas Iyer Forreshew, set out some important qualities of a good barrister, and they are integrity, courage, competence, resilience, and ability to react to fast-moving situations in litigation. They appear much like the 7 lamps of advocacy. And finally, in the words of Justice Perry, at the back of this little word wit lies the idea of knowledge, understanding, and sense. The great advocate is like the great actor. He fills the stage for a span of life, succeeds, gains our applause, makes his last bow, and the curtain falls. Thank you. Can I request Justice Deepak Mishra to comment? I would be very honored if you could comment on the speech and what has been covered so far by everyone.
You'll also have to unmute yourself. Unmute.
The last has to come first, because that was the suggestion by Mr. Bhatia. You see, there's a subtle distinction between wit and humor. A lawyer has to take recourse to extremely calculated wit and never take aid of unwarranted humor. It is because laughter has a sense of spirituality. Laughter has a sense of friendliness. Laughter can be scandalous, satirical, ironical, and sometimes extremely annoying. So one has to understand the quintessence of laughter. You see, the concept of wit comes from the idea of brevity. Brevity is the soul of wit. Hamlet speaks these words, but in a very prolonged way, and that is why Shakespeare is sometimes criticized. But there are some critics who say, just understand that conception. Brevity is the soul of wit. Other ideas that mingle with Hamletian thought, just ignore. So to have a sense of wit, you must have the thought on your toes. One, you must have the vocabulary. Third, you must have the control over ideas. What Mr. Bhatia has said, quoting from various authors, those are the real examples of wit. All the listeners must be extremely careful to understand what he has stated. It's extremely wise and explanatory. I must admit that. I'll tell you a British humor, how annoying it was, but nobody took cognizance of it. Sir Winston Churchill, he was not the Prime Minister then. He was asked to comment, sir, what do you say about the delegation of England sent to USSR? The delegation comprised of George Bernard Shaw and Lady Astor. Churchill replied, look, both of them constitute a circus and people in Russia love circus. It's absolutely annoying, but anyway, nobody took it seriously. That is different. In court, everything is taken seriously, and that is why when you really exercise the prowess of wit, you have to be guided by the statements made by Mr. Bhatia with absolute care, caution, and example. Now, coming back to Mr. Gupta, I have been asked to comment on everyone. You have taken us to Mahabharata, to Lord Krishna, and there before to Angad. They are absolutely correct examples. Now we are discussing about these epics. So I am reminded of Vibhishan. Vibhishan was the younger brother of Ravan, the demon king. While Ravan was issued the direction, kill this monkey, that is Hanuman, Vibhishan said, don't do it. He is the Duta, he is an ambassador, he is a diplomat, and you cannot kill a diplomat. Ravan doesn't listen, he kicks Vibhishan. Therefore, in Indian culture, in Indian legal culture, Vibhishan is regarded as the first amicus. So that's for Mr. Aruneshwar Gupta. As far as Mr. Sharma is concerned, he was extremely logical, I would say chronological, absolutely spirited with reason, connected law with mediation, advocacy with real spirit of advocacy, and really meant it. You spoke from the bottom part of your heart. As far as Suruchi is concerned, he batted for the feminine assertion. She was speaking about courage. Of course, she turned the phrase. I have said courage is the mother of all virtues. She said that the courage is the mother of all the lambs. I mean, the qualities of advocacy. It's also absolutely correct. She has given examples of courage and also was extremely articulate with regard to the concept of courage and the necessity of it in the legal profession. As far as Mr. Santan Krishnan is concerned, he talked about profession and the fellowship and the cricket. In the world of sports, remaining calm and cool matters. He has gone into the origin of fellowship. He also talked about what is the bar. I will not name the council. Sometime in the year 1995, a council appeared before a court and he said, bar in the world is one. And that is the concept of fellowship. That is what Mr. Krishna has propagated today. Now coming to the Judge Colin Forrest, he has referred to me, I have referred to him. We have said our intellectual spirituality and spiritual brotherhood. He was absolutely clear as crystal and he said what he meant and he meant what he said. And that is what intellectual honesty is. And lastly, to the mayor, she is the epitome of courage. As Mr. Bhatia projected before us, how many people can really manage that kind of fire and really stand up to the occasion? Only time can say. She has really shown courage, and courage in the public life deserves to be congratulated. And I congratulate you, ma'am, from the core of my heart. Thank you. Thank you very much again.
Thank you, sir. That was absolutely probably the cream of this webinar, I must say. To get your insight into every speaker. We do have one last very special speaker with us, and I'm going to introduce her to everyone. We have with us Dr. Deborah Dupre. She's the founder and president at Relationships at Work located in California, USA. She delivers private, confidential, and customized coaching to professionals in dispute resolution. A professional podcaster and a host of the program Decoding the Conflict Mindset. A renowned keynote speaker who has always inspired listeners to embrace a more mindful and compassionate life. I am truly honored to know Dr. Dupre, who has been very kind to accept this invitation for this webinar, despite an almost 12 hours of time difference. She remains my inspiration. Believe it or not, she has turned up at my workshop, which was 3:30 a.m. in the morning for her. And that is why I am so honored to have her with us, because of her commitment to teach and contribute to other people's learning. I now request Dr. Dupré now to share her observations about the program and enchant the audience with her inspiring words. Doctor, the stage is yours.
Thank you so much, Jagdeep. It's an honor and pleasure to be here with you among so many learned legal professionals. I first want to say thank you to Justice Misra for such an eloquent overview of all of the speakers and such learned observations and takeaways from each and every presentation. I'm so inspired by hearing everyone and learning from all of you. It's just invigorating, even at this very early hour of the morning, my time. So thank you very much. I had the honor of meeting Jagdeep in a workshop that we sponsored here in the US, but internationally a couple of months ago. And I was impressed by his dedication to getting up so very early in his time to participate and contribute to our webinar series. You know, it's interesting. I come to you not from a legal background, but I've worked actively with the legal professionals throughout my career of over 30 years, but with the deep understanding of the human beings in conflict. And so I do have some different perspectives, and I'm just intrigued by the lamps that have been spoken about today. And I'm inspired because of a program that we have here locally in San Diego called the Lamp of Learning. And to me, all of the concepts that you have brought to the light today, hence the word lamp, are really all about learning. It's continuing to learn about the human beings that we represent in whatever field that we are. And I love the concepts around courage. And I oftentimes speak about it takes courage to be curious, and yet it takes curiosity to be courageous. And so it's really about, what can I learn about where people are coming from, and how can I present that in eloquent ways? I love the whole ideas around integrity and eloquency, mastery. And I particularly like what Ms. Agarwal had to say about being the courage to be visible, because we do need to speak out for people who are unable to speak for themselves. And yet what that takes is really the ability to listen to what they have to say. So one of the things I'd like you to do right now is to write down the word listen, the English word listen, L-I-S-T-E-N. Actually, I want you to write that down. And then I want you to write down the word silent, S-I-L-E-N-T. And I'd like to hear from you or see from you. What do you notice about those two words? I think Jagdeep already participated in this in one of my exercises. What do you notice about those two words? Well, to listen, you first have to be silent. And it's not just being silent with what comes out of your mouth, but also being what's going on in your head. Because to listen, you really have to be present. What are the concerns of people? What are their beliefs, their expectations? What are their assumptions or attitudes? What are their concerns or challenges? What are their hopes? And then also, what are their fears, values, and needs? And so as advocates of people in legal matters, what's really important to them? And another premise that I like to work with is that, and this was said earlier, as far as understanding the facts, the principles, the evidence, the propositions, and being reasonable about that. Another way of coining that would really be, what are the facts of what's there? And by basing things on facts, it helps people, it helps ground people in their emotional intensity. And that was also mentioned earlier too, as far as people are emotional. Absolutely. People get emotional about things that are of concern to them and what matter to them. But then it's also important to focus on what's the impact of what's happened on them. And I like to use the word impact rather than emotions, because a lot of people get caught up around emotions. And so if we talk about impact, that addresses that in terms of, how am I impacted by that? And then what's important to them for how they move forward. Because there's always a historical background, right? What happened, happened. But then we have to talk about what's going on in the present. What's happening right now. And that's oftentimes the legal matters before us. And then what's important for them in terms of how do they move forward. And that gets into the values of what people are concerned about. And so facts, impact, and importance. And it's a way of moving people through whatever the concerns are. And in that regard, I like to go back to the lamp of learning. And so what can I learn from you? What can we learn from each other? And what's at the core of all of this? Because then that gets back to the integrity of human beings. And so I just love all the messages that have been said today. And the advocacy of speaking for people who cannot speak for themselves, and going beyond that, shedding light on the situation, but also being deeper in terms of what's really important to people about what's going on and how to move forward. And with that, I am just so I'm reminded. I heard words talked about in terms of self-actualization, and that goes back to the heart of what I love as far as the psychology of people in Maslow's hierarchy of human needs. And one of the things that caught my attention about self-actualization is a way of reframing that. And that's a key element of what we do with people, is how to reframe the negative situations into neutral or positive situations. And self-actualization, for me, reframed or recoined, is really about self-development. And so we are always learning, hopefully living what we learn, and then growing from that experience. And again, that ties back to the lamp of the 7 principles all of you have been talking about throughout this presentation. And it then deals with, I'd like to share with you, as Jagdeep said, as I am a podcast host, and shortly after the pandemic started in 2020, I had Dr. Justin LaPalooza on my show, and he is a psychologist, and he works a lot with people in the employment arena. And what he emphasizes that, the world is definitely changing. There's no doubt about it. There isn't, I think, a person across this globe that hasn't been impacted by what's happened in the last year. And I continue to use these key phrases from him all the time, in that what people are really looking for today is to hear me, to protect me, to prepare me, support me, care for me, honor me, and respect me. And so if we can think about those kinds of words, whatever we do with people, in whatever matter we're presented with, it takes us all back to that we are all human beings. We're all part of the human race, no matter which walk of life we come from, but we are all people who have basic needs. And when we can help address and identify those needs and really carry it out, then we're really achieving the 7 principles of the lamp. Again, the lamp of learning. And so I thank you again for the opportunity to be here and to be present with all of you. And, I said this the other day, is that I always look for the silver lining in whatever adversity we are presented with. And while this has been a very difficult 15 months or so, look at the opportunity we have to be engaged in this kind of webinar and to learn and connect with people across the world in ways that we probably never would have before. And so I thank you again for the opportunity to be with you and to learn from all of you. And hope that I've shared some words with you also that are meaningful, impactful, and hopefully our paths will cross again. Dr. Deborah Dupree, thank you.
Thank you, Dr. Dupree. That was very, very softly spoken, kind words. I could literally feel in your words the empathy towards the dispute resolution and, you know, people involved in various dispute. And I love the way, you know, you suggest how to, you know, engage with this. So we will definitely be honored to have you in more programs in future, and I will definitely be in touch with you. Thank you so much for joining us so early in the morning from where you are. Thank you. Before we move to a vote of thanks, which will be delivered by Ms. Suruchi Agarwal, I'm just going to ask some quick comments from a former judge, Colin Forrest, who is literally midnight where he is right now. So, you know, at one end we have 5:30 in the morning and we have midnight at another place. So can I request Mr. Forrest to come and quickly give comment before we head towards vote of thanks? You got to unmute. You have to unmute. Yeah, there you go.
Got it. Thank you, Yagdeep. It's not quite midnight, but it's certainly starting to get close. That's what when I spoke before, I highlighted how amazing I think modern communication is. And one thing we've learned during the pandemic, particularly, is how well Zoom and Teams and such software can be used to connect us all around the world. Indeed, during the pandemic, when I was still sitting on the court, we were conducting, my judicial colleagues and I, we were conducting all of our trials like this online, and some of the judges were even staying at home and conducting the trials from their offices at home. So sometimes there are silver linings in clouds, although the pandemic has been terrible, and it's something that I wish we would never have experienced in the world. There are some positives that have emerged, and this form of communication and meeting and having workshops and even court hearings is fantastic. Now, because I know from having a look at the people who have participated in this program tonight that a large number are, of course, in India. And I think I went to India once a long time ago. I feel deeply honoured to be able to participate directly into a workshop, effectively teaching young Indian advocates skills of advocacy, and to be able to join in with such esteemed people from the Indian subcontinent is an absolute privilege. Yagdeep, I especially want to give you credit for organising something like this from Western Australia all the way to India. And it was a good idea, I think, to focus on something like the 7 lamps of advocacy. I strongly believe that having goals in life is a very important thing. We always need to look to the future and set ourselves targets, goals, expectations, even hopes and desires. And for young advocates, having these ideas such as 7 lamps, which is a good way to describe them, and to focus future progress towards improving their advocacy skills and and by doing so improving their professional capabilities and outcomes, as 7 lamps or 7 lights or 7, whatever you want to call them, but there are goals they can always focus on and think about whenever they are in a situation in a courtroom or in a mediation where they think some humour might be appropriate or wit. They'll think about things they learnt tonight. When they need to be courageous, they can think about stories they've heard tonight. All of these things will sometime or other in the life of an advocate who is moving forward in their career come back to them, and hopefully they'll be able to take something away from what they've learned tonight that they will in the future draw upon again and help them to develop. I'm sure that they will, just as all of us have, as we have matured through our careers. So again, I honour all my colleagues that have participated with tonight, and thank you, and look forward to doing something like this again one time in the future. Thank you, Jagdeep.
Thank you, Mr. Forrest. I would not have achieved this without the assistance of Nivaran, the mediators of Supreme Court of India. You know, Mr. Krishnan, Mr. Gupta, Mr. Sharma, and Ms. Suruchi Agarwal, they have relentlessly worked over this program over the last 2 or 3 weeks. There's so many discussions, so much work that has gone into it. It is mind-blowing to see such senior advocates coming to the cause of teaching the advocacy skills. So I am truly grateful to Nivaran also. We're going to head towards our vote of thanks by Ms. Suruchi Agarwal, but don't go away after that. We are going to have a question and answers session, which will be coordinated by Mr. Aruneshwar Gupta, and those questions can be directed at our special guest and guest of honor. So please don't go away. I would request Ms. Suruchi Agarwal to kindly convey her vote of thanks to all the panel and the participants.
Yes, certainly. Am I audible? Because there seems to be some trouble with the internet right now.
No, I can hear you. We can hear you.
Audible?
Yes, we can hear you. I think we seem to have lost her. We'll give her a couple of minutes to reconnect with us. In the meantime, is she back with us?
I put a request. No, not yet. I'd put a request in the chat if anybody got a question answers, but I don't think anybody come out with a question answer. So I don't think there's any questions for people, so there's nothing to answer. Everybody's so much satisfied now. I think all the lights and lamps have been enlightened, and there's nothing left to be told them.
Till Ms. Agarwal comes back, if any of the panels or chief guest or guest of honor would like to say something, the stage is yours. Please help yourself till Ms. Agarwal comes back to us. You want to say something? I think the mayor would like to say something.
Thank you very much. That's certainly been an absolutely inspiring and compelling webinar. I've written so many notes for my own personal development, obviously not from a legal perspective, but specifically about how I conduct myself in the public arena. And sometimes it's quite right when humor can be used in the right place, but sometimes it can be perceived differently. So myself, I'm actually going to be taking a very strong message that when I feel like injecting a little bit of humor, I think I'll be thinking twice now. Not that I do it very often, but sometimes to diffuse, you look to humor, but you've also got to be very mindful of the circumstances that you're in. And what do they say? Sarcasm sometimes is the lowest form of wit. But that was just an inspiring evening, and thank you so very much. So many words of wisdom, and you can see the notes that I've written on my, where's the screen there? Lots of very informative and I guess pearls of wisdom, for want of a better word. And thank you so very much. It's been an absolute pleasure.
Thank you, Mayor. I would request Ms. Agarwal, if she can hear us, to unmute and deliver the vote of thanks, please.
Unmute. Suruchi, unmute yourself.
I said before I go into an official vote of thanks, I would like to take one more moment of your time. And in that, I would like to introduce that this Justice K.V. Krishnaswamy Iyer, the one I was speaking about, has introduced an 8th lamp. And he says so very categorically in his book. Besides those 7 lamps of Justice Abbott Parry, he talks about the 8th lamp, which is tact. He says very categorically that lawyers, when they're arguing, make this mistake of getting into a quarrel with the tribunal or the judiciary. That is a strict no. So therefore is the tact which he has introduced. I'll just read out a very small passage. It is not easy to describe tact, but its absence is easily noticed. Men of unquestioned ability have suffered for quarreling with the tribunal or for standing on their dignity over trifles, forgetting their clients or for losing their tempers. They are men of parts, but without tact. So I thought since Mr. Jagdeep Bhatia compared us to research on the 7 lamps, this is what surfaced in the research is the 8th lamp which India has contributed. And now, on behalf of Mediation Steadfast, if I may say so, Mr. Bhatia, and on behalf of Nivaran, mediators of the Supreme Court, I heartily thank everyone for their time, for the words of wisdom, and the panelists too. I, for one, have thoroughly enjoyed myself and learned a lot from this session. In fact, I would call it an enlightening and an illuminating session. And I thank Madam Mayor Tracy Roberts for her expert disposition of the geography and culture of Western Australia. One comment I would like to make here, that as a child, I used to study the Aborigines and make a project like they do in school. And what I learned there was, the concept of the divide because of the property was never there at that time, with the Aboriginal culture. And I'm very glad to hear from you that in Australia, even in the councils, you are following the principles of fairness, honesty, compassion, and integrity, which is pervading the work of all the councils. I'm really delighted about that. And I really thank you for your time and having given us that wisdom about the Australian administration. Thank you so much. The next person I would like to thank is Judge Colin Forrest. His words on the importance of judgment in utilizing his vast experience of 30 years, including 10 years as a trial court judge, are very encouraging for the youngsters, not only for them, for us too. And the exercise of judgment, according to him, is probably from the inception, alongside honesty, courage, etc. For examining witnesses, points to be pressed and dropped before the judge, response to judges, knowing your brief, brevity, humility. And the most encouraging comment I find is showing mentorship to those who follow in the later years. I mean, to avail of mentorship and to give mentorship, I find is the takeaway for me in what Judge Colin Forrest has said. Thank you so much, Mr. Forrest, for taking out time at this hour in Western Australia. The next person I would like to thank is Mr. Jitendra Sharma. With his actual treatise, when he's given it a lot of thought on eloquence, and he has come up with all the various aspects of eloquence which a young lawyer must follow, ranging from the eloquence in oral advocacy and with the essentials of the facts of the case, what is to be proved, principles of law, propositions, the manner, the demeanor of a lawyer. The eloquence is reflected in all that. The speech, reasonableness, being polite, compassionate, the vocabulary, the hold on it, the personality, and that the lawyer must be in a position to make a submission in accordance with the expectation of the bench. We're really enlightened with that, not only the youngsters, but us also. Thank you so much, Mr. Sharma. The next person I want to thank is Mr. Santan Krishnan, whom I actually consider a guiding light for Nivaran, the Supreme Court mediators. This camaraderie and brotherhood, I find Mr. Santan Krishnan leading from the front in fellowship. I actually find him leading, and I really look forward to the sessions with him and the cool demeanor. And like Mr. Bhatia said, how he manages the situation, with all of us around. And we are not really those kind of people just sitting around and watching. We are all very active with our aggressive attitudes. But he, for one, really leads from the front. So thank you very much, Mr. Santan Krishnan. And I really appreciate what you said about fellowship in the court, outside the court, and beyond the court. So we will try to follow that. I don't know about the youngsters, but we will certainly try to follow that. Coming to Mr. Aruneshwar Gupta, I am glad that we are evolving. Mr. Gupta, I'm so sorry to say too much, just so senior to me. But the last session that we had on the Bhagavad Gita, I heard you saying that Arjun did not tell, Krishna didn't tell Arjun to fight. Today, I find a slight change in that concept where you say he led him to where he wanted him to go. So the entire attributes of advocacy, which you've derived from Angad, as also Krishna, while giving a discourse to Arjuna, and with all the attributes of demeanor, speech, mannerism, what all qualities you should have, is very enlightening. And I'm really thankful for the entire. But I find the most exciting part is a real insight of your personal insight into all the legal luminaries of our profession, whom we would not have had, the opportunity of meeting. Maybe yes, Soli Sorabji sir, Mr. Nariman, and they're so apt, like Mr. Garg in the National Socialism. I find it to be the most exciting learning that we've got from you today. So thank you very much. Really, thank you. And now coming to Madam Dr. Deborah Dupree. I must thank you very much for these invigorating comments. First of all, I must again thank you for joining us at this hour in the middle of the night from 2:30, I believe, and it must be now coming to 4:30 a.m. in the morning. We call it the Brahm Muhurtam. So you have spent your time. I don't know whether you understand it, but it means a lot to us. And besides your whole concept of active listening, which we try to follow in the mediation. I mean, we are all mediators here, probably most of us. So we are very grateful for having introduced these concepts and to deliberate with us on these issues. It's a huge learning experience. Thank you so much for it. I hope I've thanked everybody on behalf of Steadfast Mediation, as also Justice Deepak Mishra. I have not thanked, I've kept him for the last. Because I find the speech to be so enlightening, sir, as always. I remember a lecture when Mr. Aruneshwar Gupta had released his book on the Bhagavad Gita. I was absolutely enamored. I had no words when I heard the discourse on the Gita from you, extempore. And it actually related to real life. It was so enlightening that I can't describe it to you. And so was today's lecture. It was a tremendous learning. I'm not able to assimilate the whole thing to tell the audiences right now, but it is a very stimulating lecture, and including the various quotes and the examples. We are very thankful to you, Justice Mishra. And of course, the summary that was made by Justice Mishra of all the speeches that have been made were really so apt. And I'm very grateful for your time, Justice Mishra. Thank you so much. And I thank all the participants and the dignitaries, and especially the young participants who are here. And on this behalf, we have learned so much. And I thank Mr. Jagdeep Bhatia for having visualized and conceptualized this whole webinar, and for picking up such an exciting topic of 7 lamps, and also your contribution to the wit and humor, and the distinction between humor and wit and wisdom is a takeaway for me today from this webinar. So I thank you all with a lot of deep sense of appreciation. Thank you so much.
Mediation Steadfast, based in Perth, Western Australia, offers alternative dispute resolution, ADR, for family disputes, business disputes, and employee relation issues. Mediation is your opportunity to avoid full-blown litigation or trial. Mediation is an alternative to going to court. Rather than have a judge decide on your matters, with mediation you can come up with your own solutions with the help of an accredited mediator who is a neutral person, who has expertise in the process, and who does not take sides. Our FDR, Family Dispute Resolution Practitioner, can help people affected by separation or divorces to sort out a range of issues relating to property, money, and most importantly, to develop a parenting plan to set out arrangements for their children. At Mediation Steadfast, we facilitate the meeting in a very professional environment, either in person or through remote audiovisual network, where you are still in control of the outcomes, which is a relief. Have an idea about what you want? Give Mediation Steadfast a chance to help you to be creative about your solutions. You can determine the way forward and negotiate some kind of settlement or an agreement that you are in control of, instead of something that is being dictated or handed down to you. What you discuss remains confidential, and what you have decided in mediation can be made to work. You can make it work well and be happy about it. There are no winners or losers at Mediation Steadfast. For with some flexibility, you can reach solutions that are appropriate, functional, and healthy for your mental well-being. Whether it's family, business, or employee relation disputes, you can create ways for conflict resolution right in the mediation agreement. You can say, okay, in the future, if something comes up that we had not anticipated, here's what we're going to do about it. Decide on a tentative agreement about matters before you decide to go to trial again. What you create from this process, you can and will adapt to with time. You can always revisit mediation in future. It feels so much better and it works. Mediation is a powerful alternative to some of the less favourable options. You can find more information about our facilitative mediation on our website, www.mediationsteadfast.com.au. Please share this with someone else you think will benefit. Make alternative dispute resolution a decision for reconciliation.